Trial resumed. Jury not present.
The court said, "Note your appearances, please."
Mr. Finkel said, "Ryan Finkel and Justin Horton for the government. We'll be joined by the rest of the team shortly."
Ms. Schrofa said, "Good morning, Your Honor. On behalf of Mr. Guo, Sabrina Schroff, and Scott Skirrick, Mr. Kamraju will be here shortly."
The court said, "Is there anything you'd like to bring up before we start?"
Mr. Finkel said, "Your Honor, the government has a few issues. I think I'll start first with the victim who is on the stand right now. First, just at the outset, the direct of that victim was approximately an hour and 10 minutes. I think the cross has so far been about 50 minutes just in terms of what is left for today. But to get to the heart of the issue, last night about 11 o'clock or so, the defense produced an exhibit to us marked DX 7016. Can I provide a copy to the court?"
The court said, "Go ahead."
Mr. Finkel said, "This appears to be the victim's resume, and a link to a profile that she is online. There is a very superficial redaction of that profile. There are a number of reasons I can think about why such an exhibit is improper. The first is relevance. Maybe that's the simplest way to deal with it. I can't understand how a victim's resume is in any way relevant to whether or not she was defrauded by Miles Guo. To the extent they're trying to show that she was an auditor or involved in risk management. Those issues were covered, asked and answered many times yesterday, so that's number one. Number two, Your Honor. If she is a victim, and I think that this resume, especially in context of what other exhibits were introduced yesterday, and the line of questioning against this victim, which from the government's perspective is just designed to harass her, violates her rights under the Crime Victims' Rights Act. And, Your Honor, there are, of course, confrontation clause issues that arise when a victim takes the stand. But citing United States v. Bannister, this is 2023 WL 259-6890. It's a Judge Engelmayer opinion. The Crime Victim Rights Act requires district courts to implement procedures to ensure that crime victims are accorded, among other rights, the right to be reasonably protected from the accused, and the right to be treated with fairness and with respect for the victim's dignity and privacy. Judge Engelmayer goes on to explain that, while the Confrontation Clause of the Sixth Amendment guarantees defendants the right to confront government witnesses testifying against them, it is not absolute. Citing a Supreme Court case, California v. Green, a defendant's rights under the Confrontation Clause must yield to accommodate other legitimate interest. Citing a Second Circuit case and a Supreme Court case. For instance, trial courts have wide latitude to impose reasonable limits on cross-examination based on concerns about, among other things, harassment, prejudice, or witnesses' safety, quoting a Second Circuit case, and quoting Federal Rule of Evidence 611b. If the government, according to Judge Engelmayer, provides a reason to limit disclosure of identifying information in open court, the defendant must demonstrate a particularized need for such disclosure. That case, Your Honor, was in the context of a VUSR in which Judge Engelmayer sealed from the public record a victim's identity and replaced it with initials. But Judge Engelmayer, in this opinion, and I have a copy for Your Honor if you like it, cites to criminal cases, including U.S. v. Maxwell and other criminal cases where pseudonyms were used. We're not using a pseudonym here, but nonetheless the Crime Victim Rights Act does protect victims from harassment and prejudice. But more to the point, Your Honor, there is no proper purpose to introduce this victim's resume to make her a target of harassment and attacks online or in other ways. And so, because it's irrelevant, because it was asked and answered, and her history was covered yesterday, and because of the Crimes Victims' Rights Act, this exhibit should be excluded.
The court said, "Ms. Schroff, What would the resume accomplish that you have not already accomplished by your detailed questioning of her concerning her credentials and her work history?
Ms. Strofa said, Your Honor, we don't need to introduce the resume into evidence. We provided it to the government because the witness testified that she did not take an accounting class, and she did not have accounting lessons while she was an undergraduate student in China. I was considering crossing her with it and using it for impeachment purposes. So in an abundance of caution, we sent it to the government. There would be no scenario under which I would disregard the court's ruling and introduce into evidence somebody's address. So that's not where we're going. Thank you.
The court said, so essentially you expect to be asking here, isn't it true you took an accounting class in this year?
Ms. Strofa said, that was it. I wasn't even sure I was going to do it, but we decided to go ahead and send it anyway. The document is public. We only found the document on the internet. It's still up.
The court said, my question for you is, do you intend to use it today to try to refresh her recollection?
Ms. Strofa said, no, to impeach her possibly, because she in fact said, I did not take an accounting class.
The court said, right.
Ms. Strofa said, that's the only reason I would ask.
The court said, I'm trying to understand what your question would be. Is it, didn't you upload to the internet a resume stating that you had taken accounting? Is that the question?
Ms. Strofa said, no, Your Honor. What I was going to say is, yesterday you testified you did not take accounting classes. Correct? Let me show you document marked as X. Isn't it a fact in your resume you stated otherwise? And point her to the thing and that would be that. It's just pure impeachment. I'm not seeking to introduce the document. I'm not really sure I'm going to do it. It was just a thought.
The court said, Mr. Finkel.
Ms. Strofa said, only because it's relevant under Litvack it was a thought I had. And again, nobody is seeking to introduce any unredacted documents or do anything untoward here. Obviously it's just, I don't know exactly what happened why we didn't send it to them redacted. It's been a long night.
The court said, all righty. If it is her plan, Ms. Schroff's plan to state as she just said. Yesterday you said you didn't take an accounting class. Isn't it true that on your resume you stated that you did take an accounting class? That's pure impeachment. It's not for the purpose of actually admitting the resume. I don't see what would be objectionable about that.
Mr. Finkel said, Your Honor, I'll have to check the transcript on that. Candidly, Your Honor, I disagree with what Ms. Schroff is saying that this is all for proper purposes and not designed for improper purposes. The government's perspective, Your Honor, is that Ms. Schroff is crossing this witness to embarrass her and harass her. Yesterday she told Your Honor that she was putting those IDs into evidence because they were going to be chats introduced. There were no chats. She just wanted to blow up who this person was online, and I don't think that's appropriate.
The court said, so she has to have the opportunity to confront the witness. It simply would be improper for me to deny her the opportunity to try to impeach the witness, so I will permit her to ask the question that I just posed in the form that I posed. It ends there.
Mr. Finkel said, I appreciate that, Your Honor, and I completely understand. And the government's point of view is yes. She's allowed to cross-examine about a witness's credibility. I agree. The government agrees. We would just ask in light of what had happened yesterday, and I'm sure I'll object that Ms. Schroff not harass the witness. That's all. And I think that our position on that is clear, and I understand the court's ruling.
The court said, well, vigorous cross-examination sometimes involves making a witness feel uncomfortable, and that simply is a reality of criminal litigation.
Mr. Finkel said, I understand.
The court said, there is a border of course between vigorous confrontation and crossing over into harassment or badgering. I have not seen harassment or badgering of this witness, and so I'm confident that Ms. Schroff will not go there.
Ms. Strofa said, thank you, Your Honor. I will be happy to show the government when the moment comes the use of the IV handle and the chats.
The court said, what is the second issue?
Mr. Finkel said, the second issue, Your Honor. And we raised this because we had a number of back and forth with the defense via email just trying to get a straightforward answer to two straightforward questions that has not been provided. The defense is going to call Maggie Sklar, who is their cryptocurrency expert. We've asked them whether Ms. Sklar intends to testify about her review of the blockchain or her review of smart contracts. It's frankly a yes or no question. If the answer is yes, we're going to file a letter on this issue because we believe it's beyond the scope of her disclosure. And we'll brief that, but we don't want to waste the court's time and file a letter needlessly. We asked that question I think 3 times. We've got circular responses. I would ask the defense to please inform the government whether Mr. Sklar intends to testify about her review of the smart contracts and the blockchain for HCN and HEO.
The court said, Ms. Schroff or Mr. Skirik?
Mr. Skirik said, Your Honor, we did indeed have a back and forth with the government on this issue. We referred the government repeatedly to Ms. Sklar's expert disclosures. In particular referred the government specifically to our April 29 disclosure. And even more specifically to Section 22 of that disclosure, which says in relevant part, and I'm quoting, Ms. Sklar will further opine that given HCN and HDO each were minted using smart contracts which can be seen on the public Ethereum blockchain, and are purchased using fiat currency and traded, they meet the common market understanding of cryptocurrency. So the 2 questions Mr. Finkel posed are answered by the particular disclosures and the other disclosures that contextualize that statement.
The court said, Make it easy for me. What are the answers? He's asking you a very straightforward question. I want to hear your answer.
Mr. Skirik said, The question, Your Honor, is will she testify about having reviewed the smart contracts? The answer is, she may testify about that, yes, that's within her disclosure. And that she reviewed the smart contracts on the publicly available Ethereum blockchain.
Mr. Finkel said, the answer is yes. And we would have appreciated just getting that straightforward answer via email instead of wasting the court's time this morning. We'll respond with a letter so the court can resolve the dispute. While we're on the topic of experts and defense case in general, we requested last night the defense provide what the government has provided, which is a list of the exhibits they intend to introduce via each witness. We have not received that. They might have a witness today, Mr. Duran testify. We don't know what exhibits, if any, Mr. Dragon testify. We don't know what exhibits, if any, they're going to introduce. And we ask the defense be held to the same standard the government was held so that the trial is efficient during the defense case, including that they provide any draft slides of work product, which would be 26.2 material, since it's prior statements of the witness, which we haven't received either. We have no summaries. We have no demonstratives. Their 26.2 material talks about demonstrative exhibits. We haven't seen them. We might have objections to them. We might not. We might be able to talk to the defense and resolve these issues without involving Your Honor or the jury's time. It would be appropriate for them to provide this to the government. We ask the court to order them to do so.
Mr. Skirik said, Your Honor, to the extent that the defense plans to introduce any documents that are not already in evidence, we will provide that disclosure to the government.
The court said, I'm sorry, Mr. Skirik, I did not completely hear what you said.
Mr. Skirik said, I said to the extent we plan to introduce any documents through the expert testimony that are not already in evidence, we will of course provide the disclosure to the government.
The court said, they're asking to know specifically what you intend to introduce, not to hear that there's a body of evidence that pertains to a particular witness.
Mr. Skirik said, maybe I misunderstood, Your Honor. I thought the question was whether we plan to introduce any new documents. I thought Mr. Finkel was referring to a demonstrative that we may use with the experts. Not documents that are already in evidence, but perhaps I misunderstood.
The court said, my understanding, and if I'm wrong, correct me please, is that they want to know what exhibits correlate to each witness that you're going to call. Am I correct?
Mr. Finkel said, yes, Your Honor. And in particular, any new exhibits they intend to introduce, and the demonstratives. The demonstratives, it says 26.2 material, in effect reviewed demonstrative or demonstrative exhibits. We don't have those. If they're going to put it in front of the jury, even the demonstrative, they should give to the government.
Mr. Skirik said, "Of course, Your Honor. We understood that. And that's what I understood Mr. Finkel's point to be, was demonstrative or new exhibits. And of course we will provide that. No decisions have been made with respect to the use of demonstratives that would require us to produce them at this point."
Mr. Finkel said, "Just so Your Honor knows, one of their experts may testify today. We have not received the demonstratives. We don't know if they're introducing any exhibits. If the answer is no new exhibits will be introduced through this witness, then just tell us. Then we know, and we could be more efficient with Your Honor's time and the jury's time. If the answer is maybe, then give us the universe. We've done that. We've said, here's a body of 30 or so exhibits or more sometimes. It will be a subset of that. They haven't done that. And frankly, Your Honor, we're at a point in this trial where efficiency should be the rule of the day, not tactics and delay and circular answers."
Mr. Skirik said, "Your Honor, if I just may briefly. First of all, there are no new exhibits. There's no demonstrative that we plan to use with Mr. Dragon. Obviously we have continued to work with the experts who are going to be among the first defense witnesses to testify. And we didn't want to preclude ourselves from potentially, as of yesterday, being able to use something should we want to, so we hadn't made any disclosures to the government. I'm frankly just not sure what the issue is. Of course we know our obligations and of course we will disclose them. And we have no intention of using a new exhibit or a demonstrative with Mr. Dragon."
The court said, "All right. Now we know there's nothing new and no demonstratives."
Mr. Finkel said, "And that's helpful. And Your Honor, just moving forward since they have 11 witnesses or so, we would appreciate the defense works the other way, which is, instead of saying, we don't know what we're going to introduce, so we're not going to tell you anything. Tell us what the government has done, which is, here is the subset of exhibits that we might introduce. And if it turns out they're not going to, that's fine, that would make things more efficient. That's what the government has done. We also would request, and I think they should provide us some information as to the compensation for these experts. That's the government's request."
Mr. Skirik said, "Your Honor, with respect to the compensation disclosure. That's obviously a standard question that the government is going to ask the witnesses on cross-examination, which the witnesses will answer candidly. The government only raised this issue with us, I believe, in the minutes before we walked into court this morning asking for some disclosure pre-testimony. We're happy to entertain that. But the parties haven't had a chance to discuss that yet, and Mr. Finkel is raising this now for the first time with the court. So we're happy to discuss that with counsel and arrive at a mutually agreeable way to go about that."
Mr. Finkel said, "We appreciate that."
The court said, "In a word, this trial for me has been unprecedented, and I am hoping that as we move towards the finish line that the attorneys will show a greater degree of cooperation with each other. Alrighty, we'll start at 9:30.
Continued on next page.
The court said, "Counsel, I'd like to remind you that the interpreters would like you to slow down, especially if you're reading from a document. Have the jurors come in, please."
The law clerk said, "Jury entering."
Jury present.
The court said, "Please be seated. Good morning, jurors. We're going to continue with the cross-examination of the witness. Ma'am, remember that you're still under oath. You may inquire."
Ms. Shrofa said, "Thank you, Your Honor."
Wei Chen. Cross-examination continued. By Ms. Shrofa.
Good morning, Ms. Chen.
Good morning.
Ms. Chen, you testified on direct about GEV, correct?
Yes.
And you testified that you heard Mr. Guo say that the GEV business had a bright future ahead of it, correct?
Yes.
And you testified that you watched a video where he said that GEV was going to have a very powerful platform, correct?
Yes.
And you said on direct testimony that you heard Mr. Guo say that he anticipated GTV would be successful, correct?
Yes.
And that was going to be very powerful, correct?
That is going to be very valuable.
I'm sorry.
That it is going to be very valuable.
That it was going to be very valuable. Thank you. And you also understood Mr. Guo to say that he would be working towards acquiring software for the platform, correct?
Yes.
And that he would do all he could to make it a strong software platform, correct?
Can you repeat that question again?
Sure. And you testified that you heard him say that he would make it a good platform with good software, correct?
Make a good platform with a good software?
Right. He would have people working on the software behind the platform, correct?
He would have the technology infrastructure to build the platform.
Right. So you heard him say he would get the technology infrastructure to build the platform, right?
That's my understanding.
Okay. And when you say that is your understanding, what exactly is it that you mean?
That means I heard him saying that, and I take away that's a messaging conveyed to me.
And that was your understanding back then, correct?
Back in the time when I heard it and decide to make the investment.
And sitting here today, do you by any chance know if there was any undertaking of a technological infrastructure?
Can you repeat the question again?
Sure. Do you know sitting here today whether Mr. Guo or anyone at GTV took such steps? Do you know?
Such steps, what do you mean by that?
Do you know if anyone at GTV was working towards making it a good platform?
I'm not sure.
Now, you also testified that you were influenced by Mr. Guo's claims of wealth, correct?
I testified that I was influenced by him portraying as a very wealthy person.
Let me ask you a follow-up question. When you say portraying as, what did you say very?
Wealthy person.
Wealthy person, right?
Yes.
And did you know if in fact at that time he was wealthy?
From what he said at the video, I thought he was very wealthy.
My question was whether you independently knew him to be wealthy.
Mr. Finkel said, asked and answered.
The court said, sustained.
Did you do any research into his wealth?
Mr. Finkel said, Your Honor, this is with respect to the court's ruling discussed after court yesterday. Objection.
The court said, sustained.
What day did the PPM close?
PPM?
The private placement, when did it close?
I made the investment till I believe June 2nd, 2020. And if I remember clearly or correctly, there might be a day off from whichever June 2nd is. Don't quote me on exact June 2nd, but around that time. That was my recollection.
Your recollection is it was June 2nd, not June 26th.
It would not be that far, beginning of June.
Let me show you what is marked as Defense Exhibit 7015. And if I could just make sure it's just shown to the government, the court, and the witness. Do you recognize that? Ms. Chen?
Yes.
What is it?
It is a video with Miles Guo claiming bankruptcy.
Ms. Schrofa said, Your Honor, we moved DX 7015 into evidence.
Mr. Finkel said, One moment, please. Objection. It's the defendant's statements.
Ms. Schrofa said, I'm going to show it for the effect on her state of mind. I don't care if it's true.
Mr. Finkel said, This is February 2022.
The court said, if you'll step up.
Continued on next page. At the sidebar.
The court said, to show the effect on her state of mind?
Ms. Schrofa said, he declares bankruptcy. He does so publicly. She testified that she's influenced in her investments based on his wealth. After he declares personal bankruptcy, she continues to invest. That's it. State of mind, her knowledge that he openly says he's filing personal bankruptcy.
Mr. Finkel said, You can't ask those questions without introducing the video of the defendant's statement.
Ms. Schrofa said, Of course I can, but that doesn't mean that I should or I'm required to. My client is entitled to a robust defense, and this is admissible for the purpose of which I stated.
Mr. Finkel said, Robust defense does not overtake the federal rules of evidence. And the defendant's statements are not admissible by the defendant, and that's the purpose. To the extent there's a dual purpose, which is to say the effect on the listener, the victim, and also the statements of the defense, the defendant, then the court has discretion to decide how to proceed. The government's point of view is that the court should not permit playing a video of the defendant's statements and allow Ms. Shroff to ask the question about what effect, if any, Mr. Guo's declaration of bankruptcy had on her analysis. I would also add that the fact that the defendant declared bankruptcy seems to be suggesting that essentially the victim should have known better, that she should have known that Mr. Guo wasn't really rich, and that from the government's point of view is that it infringes on Your Honor's ruling about the sophistication of victims.
Ms. Shroff said, Your Honor, other than the fact it is admissible, I'm not seeking to go as far as the government is attributing to me. The video is admissible to show how she went through her process. They went through her process. They are the ones who focus repeatedly on his wealth, his wealth, his wealth. I should have some leeway to cross. And the federal rules of evidence in fact does allow for the admittance of the video. And of course you can give a limiting instruction. I have no objection.
Mr. Finkel said, it doesn't allow for the admission of the defendant's statement. That's the government's point of view.
The court said, that's my understanding of the law. I'm not going to permit it. Of course you can question on that issue.
Continued on next page. In open court, jury present. By Ms. Shroff.
Ms. Chen, on February 15th of 2022, you watched a video, correct?
I knew he filed bankruptcy on February 15th, 2022.
My question to you is whether or not you watched a video on February 15th, 2022, where Mr. Miles Guo discussed the fact that he was filing for bankruptcy.
I don't remember if I watched that video specifically you talk about.
So you remember some of the videos where he spoke. You just don't remember all of the videos where he spoke?
It's been such a long time.
2022 is after 2017, correct?
Yes.
After 2018 and 19, correct?
Yes.
And your testimony is you don't remember this particular video, correct?
Mr. Finkel said, asked and answered.
The court said, sustained.
Do you recall Mr. Guo's statements that he was declaring and signing the bankruptcy petition on that very day?
Mr. Finkel said, asked and answered.
The court said, you may answer.
Sorry. Can you repeat that question again?
Sure. Do you recall Mr. Guo saying on the video that he was signing the petition on that day, February 15th of 2022?
So I think I said I did not remember if I watched that video specifically that you are referring to. And also I stated that I knew that Miles Guo filed bankruptcy on February 15th, 2022.
Did you read the bankruptcy petition that he signed?
I do not think so.
I'm sorry.
I don't think so.
Do you know if your husband watched that video?
I don't know.
Now let me move to GXVK5. May I have it brought up for everyone since it's in evidence? You recall testifying about this document, Ms. Chen?
Yes.
And you reviewed this document with Mr. Finkel when you met with him at the United States Attorney's Office, correct?
He showed me this document.
Right. And after he showed you the document, did you two go through it?
I did not go through after he showed me. I just looked at the document when he showed me.
So you only looked at the first page of the document and that was it?
He also went through other pages.
Okay. So he reviewed the document with you, correct?
That's not correct. My understanding of review is review the document entirely. If I understand when you say review, that's the meaning. So I say that's not correct because I did not review this document with him.
So is it fair to say you did not review the entire document with him?
He showed me the document. When you say review, can you clarify what does review include?
You tell me what you think review means?
Mr. Finkel said, I think that was answered already. Objection.
The court said, did you read the document word for word?
The witness said, so her question asked me, did Mr. Finkel review this document with me? So my answer to that is no. He did not review this document word by word to me.
The court said, go ahead.
How about pages by pages?
The answer is no.
How about some pages?
Certain pages, yes.
Did you choose the pages or did he choose the pages?
He showed me. Did you see this page? Just ask. As to the testimony yesterday, he showed me a page and asked me about it, and that's it.
And yesterday, when he was showing you the pages in the courtroom, he had shown you those pages before, right?
Not all of them.
So you remember what pages you reviewed with him because you're now able to tell me not all of them, right?
I don't remember the pages he showed me, but he showed me the page and asked me the information. I think some of the information is not what he reviewed, not what he showed me last time when I met with him.
You met with him more than once?
I met him more than once, yes.
And did he show you this document more than once?
No.
Well, let's see what we can talk about from your testimony yesterday. Yesterday you testified that you did not consider the risk factors in the ppm, correct?
Mr. Finkel said, misstates the testimony.
The court said, sustained.
Let's pull it up. You remember talking about the standard language in this document? You remember the judge asking you what you meant by the phrase standard language? Do you understand that?
The court said, you may answer.
Your question is, do I understand that I testify? Is that your question?
Yes, that is my question in fact.
Yeah, I remember I testify that.
And you remember the court asking you what you meant when you said that those were standard language, correct?
Yes.
And your response said, like in a legal document, it oftentimes would have the language talk about risk. Remember that?
Yes.
And when you said that, had you an understanding of standard language in ppms in other situations?
Mr. Finkel said, objection.
The court said, overruled. You may answer.
No.
And had you ever compared ppm language?
No.
So when you said that this was standard language in this document, you had no basis of comparison, correct?
Mr. Finkel said, objection, goes to the court's ruling.
The court said, overruled. You may answer.
That's just a way of my expressing how I think those are just certain terms put in a legal document. And I use standard language to explaining my understanding of terms in a legal document.
Right. But you're testifying under oath today, right?
I testify under oath by saying the truth.
Right. And the truth is that you did not ever compare the language in ppms with each other, correct?
This is the only ppm I have ever seen. I have never had an opportunity to see a ppm because Guo said this is right opportunity. I have no opportunity to even see a ppm document.
Well, you have access to Google, right?
Everyone have access to Google.
I'm sorry.
Yes.
Let me move on and show you page 29 of the ppm. Okay. Actually, I'm sorry. Page 29 is the last page of the ppm, right? The entire document is 29 pages long, right?
I don't remember. If you say it's 29, it's 29.
It's right there for you to look at.
I don't know. Does that matter if it's 29 pages? If you say it's 29, it's 29.
Okay, let's try and go to page 9. You see that document?
Yes.
And we talked yesterday about the last paragraph, so I won't go back there, okay? But this, just to give you a perspective, and let's go to page 10. You recall being shown this document on your direct testimony?
Yes.
And was this one of the pages that Mr. Finkel and you reviewed in his office?
He showed me this page in his office.
And then he asked you questions about this page, right?
Yes, he did.
And he asked you about the two figures split side by side, right?
No, he did not.
Well, I'm going to ask you some questions about that. Is it fair to say, Ms. Chen, that the figure on the left side shows the ownership structure before the ppm, and the figure on the right side shows the ownership structure after ppm, correct?
From what you're showing here, and you highlight it, yes.
I don't have to highlight it for you if you prefer I not.
The court said, don't testify. Just ask questions.
Ms. Schrofa said, I wanted to make sure I did what the witness wanted, Your Honor. And on both sides of the screen, Ms. Chen, it shows Soraka has an ownership interest in GDV, correct?
Yes.
And on direct, Mr. Finkel also asked you, and we can take that down and move down on the same page about this chart, correct?
Yes.
And he specifically asked you a question about this 5%, right?
Yes.
And he focused you on the word other, correct?
He asked me what my understanding about the other.
And you said that your understanding was that it was some overhead administrative cost, correct?
Yes, I understand it's the HR administrative hiring cost with the people talents.
And that was just your understanding, right?
Yes, because you need talents, the people.
Because of what?
You need the talented people.
You need talented people?
To develop GTV business, that's my understanding of what this other is for. To hiring talented people to grow and develop GTV business.
Okay. But you would have talented people if you acquired companies that had talented people working for them, correct? Like as it says on number 1, acquisition of companies to strengthen and grow GDV. If you acquired a company that had a lot of talent, that talent would also come in under the approximate 70%. Correct?
Mr. Finkel said, objection, form, and calls for speculation.
The court said, sustained.
Is that your understanding?
The court said, sustained. I sustained the objection. You don't need to answer.
What is your understanding of acquisition of companies to strengthen and grow GDV?
My understanding is acquire certain software or technology may have already developed to some extent that you can grow upon it with talent you're hiring for GTV to make it more successful.
And what does acquisition of companies mean to you?
Acquisition of companies that already develop somewhat model of software or technologies that are in place.
To develop that technology, you need people, right?
You would need more than just the people you acquired from that company. If you make a big business successful for GTV to have not just the media platform, but also doing the transaction. You cannot just acquire companies without having your own people managing the business make it successful. That's common business sense.
Thank you, Ms. Chen. Now, if we could go to page 15, please. Do you see that?
Yes.
And you were asked questions about this page as well, correct?
Yes.
You were asked who Mr. Blanton was and Aaron Mitchell was, correct?
I don't think so, but maybe. I don't remember.
And then you see at the bottom it says sponsor and advisor of GTV Media, correct?
Yes.
Could you read the first 2 lines for me?
You talk about the 6.3 sponsor and advisor?
HM.
I think I read it, yes. Do you want me to read it again?
Yes, please. I would really appreciate that. Thank you.
The sponsor and advisor of GTV Media, Mr. Wengue Guo, aka Miles Guo. Huan Kwok or Miles Kwok is a billionaire, a successful businessman and a dissident in China.
Keep reading.
He knows deeply how the Chinese Communist Party CCP deprives the people of China of human rights, justice, freedom of speech, freedom of press, and freedom of religion. He's dedicated to overthrow the CCP regime, to bring back truth, freedom, and justice to the people of China. Miles Guo is the key host of the GTV Media.
This section, it's fair to say, describes the billionaire as the sponsor and the key host, correct?
That's the word by word in this paragraph.
Thank you, Ms. Chen. You can take that down. Now, when you read this document, did you recall the role that Mr. Bannon was going to play in this venture? Did you focus on Mr. Bannon at all?
I know he was listed as the non-executive director, and then that's it.
Did Mr. Bannon's presence as a woman come as a negative for you to invest in GDV?
Mr. Finkel said, object to the form.
The court said, rephrase that, please.
As a woman, were you offended that Stephen Bannon was going to be part of this project?
Mr. Finkel said, same objection.
The court said, you may answer.
I don't understand this question.
I'll move on. Now, let's go to page 15 of the same document and moving down to 18 to 19. You were asked questions yesterday about the risk factors here, correct?
Yes.
And the document lists the risk factors, correct?
Yes.
The document says that the company has no operating history, correct?
I did not see it. Where do you see that? You ask me when I'm reading this document now, or asking me about the time when I was reading this document when I made the investment?
Well, I was asking you about this document when you read it before you made the investment.
Your question is asking me, did I read the risk factor saying it has no operating history?
Yes, ma'am.
I don't remember I read that part when I made the investment back then.
How about did you read that the company's management has broad discretion in how the company uses the net proceeds of the sale of common stock?
Yes, I remember that 100% exactly.
And could you tell the jury what your understanding is of net proceeds?
My understanding of net proceeds?
Yes, ma'am.
My understanding of net proceeds is you will have sales proceeds or profits that minus the operating cost, and then that equals the net proceed.
And if you included the operating cost, would that be gross proceeds?
If you're including, I don't know.
Well, let's go to page 25. And on page 25, what does it say in bold? The company does not intend. Could you read that?
You are not entitled to receive.
No, just the title.
The company does not intend to pay dividends for the foreseeable future.
And let's go below that where it says, Soraka owns a controlling interest. Read that part at the bottom.
Soraka owns a controlling interest in the company and can exercise significant control over the company.
And that's on page 25 of 29, correct?
It shows on 25 here.
And we can take that down. Now, Ms. Chen, you also testified about receiving stock certificates reflecting your GV shares, correct?
I testified that I was able to log into website to purchase 2 papers.
And you purchased them yourself, or did your husband purchase them?
We log into account together, and I watch him pay for it.
I see. And you talked about that process with Mr. Finkel when you prepared for your testimony here, right? You talked to him about that process, right?
When you say I talk about the process, meaning I talk about the process of going to the website and downloading the paper, is that what you're asking?
Yes.
I think so.
But it was really your husband who went to the website? You were watching, right?
Mr. Finkel said, asked and answered.
The court said, sustained.
Did Mr. Finkel ask you for a copy of the certificate?
No.
Well, let's show you DX60672. Do you recognize that document, Ms. Chen?
Yes.
Ms. Shrofa said, Your Honor, the defense would move to admit 60672.
Mr. Finkel said, Are there any other pages in this exhibit? The FBI?
The court said, Are there any additional pages?
Ms. Shrofa said, We're showing them to the government now.
Mr. Finkel said, May I inquire one question?
The court said yes.
Mr. Finkel said, Ms. Chen, did you send this document to?
The witness said, I don't remember.
Mr. Finkel said, No objection.
The court said, It is admitted.
Defendant's Exhibit 60672 received in evidence by Ms. Shrofa.
And if we could just publish that to the jury. Ms. Chen, you sent a lot of documents to the FBI, right?
Can you define what is a lot of documents?
You sent a lot of documents?
Mr. Finkel said, asked and answered.
The court said, She asked if you would define what you meant by a lot.
I didn't hear that at all, so I apologize. Did you send more than 50 documents?
I don't think so.
How about 30?
I don't remember if it's I don't count. I sent some documents, yeah.
We can take that down. I'm sorry. I just want to make sure the jury saw all pages. Now, yesterday you also testified, did you not, about the Rule of Law Foundation, correct?
Yes.
You testified that you donated $30,735, correct?
I don't know if I testified that exact number. I just say I donated about $30,000.
You recall sitting here today that was 3 days in a row, September 28th, 29th, and 30th?
So can you repeat? What do you mean the 3 days? Can you clarify your question?
Sure. You first donated 400. That was your husband who did the first donation, correct?
I want to make it clear, when you say my husband did it, we jointly did it. But then he's the one who processed it, so that has his name. So I want to make it very clear as we jointly did it.
Okay.
So you can make it clear in the future, not just always say your husband did it.
Your husband did it. You jointly decided. Is that accurate?
My husband is the one logged in the web. And again, I was there with him, so we did it together. If you can make that clear. You cannot always say my husband did it.
But your husband did in fact did it? He logged in and he paid for it?
The court said, Ms. Schroff, when you use the word did, you need to define for the witness what you meant.
Your husband logged into the website, correct?
Yes.
He used his password, correct?
I don't know if you need a password to do a donation. You mean log in the computer or log into the website?
I mean log into the computer. He logged in, right?
Yes.
And he went through the steps of doing the donation, correct?
He go to the website and he went to website and he's the person process it, yes.
Thank you. And the processing was on September 28th, 29th, and 30th, 3 days in a row, correct?
I think you're mixing up the time. You're talking about donation $400 back in 2020. And you also talk about 2022. You're making it very confusing to me. I don't know what you're asking.
Well, first of all, I'm just going to ask you to slow down because the interpreter is going to have a lot of trouble. And let's see if we can start again. There was a $400 donation in the first instance, correct?
Yes.
What year was that?
I think it's in 2020.
And what year was the $30,000 donation?
2022.
Okay. And the 2022 donation was for $30,000, correct?
Yes.
And that was 3 days in a row. 10, 10, 10, September 28th, September 29th, and September 30th, correct?
I don't remember exactly.
And you thought, and you told the government that you would not have made that investment, as you call it, if you didn't think that you could get your money back from the Rule of Law Foundation. Do you remember that?
Mr. Finkel said, I have a form objection. It's confusing.
The court said, you may answer.
Sorry. I didn't understand your question. How would my investment have anything to do with a donation? I didn't quite understand your question.
Do you recall telling the government that you would never have donated this money if you didn't think the Rule of Law Foundation wouldn't give you the money back?
I never say that. I don't think so.
Let's show you 3,526 at page 2. Do you see it on your screen, ma'am?
I saw it on my screen.
Does that refresh your recollection that you used a credit card to invest $30,735 in Rule of Law? You thought it was an investment. And you would not have made that investment if you did not think you would get the money back?
I don't recall saying that at all. I think it's maybe taken down differently.
Thank you. Let's talk about G Club. Okay, you testified about G Club yesterday. And you testified that it launched in October of 2020. Is that right?
Yes.
And you tell me whether it was you who bought it or your husband who bought it. The G Club membership in October of 2020?
Let me make it clear, we never bought G Club membership.
Ma'am, what year did you sign on for a G Club membership account?
So I think your question asked me is in March 2021, who bought the G Club membership. So what I'm responding to you is, your statement is not correct. We never bought any G Club membership.
You can define it in any way you choose, Ms. Chen. There is something.
Mr. Finkel said, objection to the commentary.
The court said, stick to the questions.
You know something called G Club?
Yes.
Was there something called the G Club membership?
Yes.
What was the G Club membership?
I don't know what is G Club membership.
Well, you gave money to that institution, right?
I gave money to the bank account that is given to me by the MOS Farm volunteer.
And for what reason did you give them the money?
To GTV shares, for additional GTV shares acquisition.
And what website did you go to follow through on this transaction?
I follow up with the MOS Farm volunteer, confirming that the money I sent to the bank account be given to me has been received. And then they send me the confirmation confirming that the money has been received.
Right. And you said you got a confirmation that the money had been received by an entity called G Clubs, correct?
The MOS Farm Discord confirmation just said this is amount. It's been received.
And received for what?
Confirm.
What was the company?
You mean the money where I send the money to? What's your question?
That is my question. What company were you purchasing a product from?
I did not purchase any product from any company. I made it loud and clear. I sent the money to purchase additional GTV shares.
Let's show you GXVB24. You testified about this document yesterday, correct?
I testified this is a document with instructions provided to us to complete after we sent the payment to Crane Advisory.
And the document says the purpose is G Club membership, correct?
I did not see that.
Mr. Finkel said, objection.
On the right under the word purpose. I don't want to highlight it for you, but the right column. G Club membership purpose, right?
That's the instruction given. There's no choices.
Well, the choice is to not fill the document out at all, right?
Mr. Finkel said, object to the commentary.
Ms. Schrofa said, it's a question.
The court said, so keep it to the questions, Ms. Schroff.
I can't answer that question because I have already made the payment to Crane Advisory. I have no choices of not signing this document because I already made the payment. So there's no choices for me no filling out this document. Are you clear on that?
Continued on next page. By Ms. Schrofa.
Ms. Chen, you could have called Crane Advisory and asked for your money back, right? Before filling out the document?
I'm not as smart as you.
Okay. Well, do you buy things in normal, everyday life?
Mr. Finkel said, objection.
The court said, all right. So we know she buys things in normal, everyday life.
You know you can ask or change your mind within a certain period of time, correct?
Let me make it clear. I sent the money to the bank account that's given to me by the people that I trusted.
Ms. Schrofa said, I move to strike, Your Honor. It's non-responsive to the question.
The court said, overruled. Overruled. Let her complete her answer.
So I sent the money to the bank account that was sent to me by the person that I trusted. In that situation, do you think I would call the company to call my money back? And do you think I would question about the document that was sent to me afterwards to complete?
Well, you worked 15 years at a bank, right?
Yes. So what?
So you know how to ask for a refund, right?
Mr. Finkel said, objection.
The court said, Ms. Schroff, I want you to be mindful of my order regarding the subject matter.
Ms. Schrofa said, let me move to 24T. Let's just put them up side by side, if we can. Did you fill out the document based on the form on the left side, or was it your husband?
So I'm sitting here and I feel like, are you trying to ask me am I tricked into signing this document? And if so, I think yes, I was tricked into signing this document.
That's your position, right? I understand that.
The court said, so Ms. Chun, listen to the question and then give an answer. As opposed to volunteering additional information that was not asked about. Go ahead.
Who signed that form for you? Was it you or your husband?
My husband signed it for me.
And were you there when he signed it?
This one, I did not.
And do you know how he sent the form in?
So in this situation, he told me he was contacted by MOS Farm. MOS Farm volunteered to complete a document because we sent the money to Crane Advisory. In order to complete this investment, he need to sign this document. He told me that, and he signed. I don't know what happened there.
Okay. So you don't know how your husband submitted this form. That was my original question.
He submitted it to the MOS Farm volunteer. That's who sent him this document.
Okay. And what did the farm volunteer do as the next step?
I don't know. Confirm receipt of the document?
So it's fair to say you do not know what happened between your husband and the Mountains of Spice Farm volunteer after the document was submitted. Correct?
I do not know what the MOS Farm volunteer do after they received this document.
My question was, do you know what the farm volunteer said to your husband after he had submitted the document? That was my question.
So your question is asking, after my husband sent this document to MOS Farm volunteer, do I know what the MOS Farm volunteer responded to my husband? Is that your question?
Yes, ma'am. Actually, that is my question.
I think they confirm receipt of this document.
Okay. Now to actually have this document go through, your husband had to affirm the terms of the purchase. Correct?
I don't understand that.
You had to say, yes, this is what I want, correct?
I don't know. I don't understand what you're asking.
Did there come a time when your husband was in the process of activating the G Club's membership? Do you recall that?
I think what happened is, Miles said we were going to get a free G Club membership for the GTV additional shares we are purchasing. However, we never got the free G Club membership for the $210,000 we sent to the 2 accounts that were given to us. We only got maybe one of them activated, but not the other 4. So if that's what you're asking, that is what's happening, because the free G Club membership were not activated.
Ms. Shrofa said, I move to strike, Your Honor. And I repeat the question. To purchase.
The court said, overruled.
Let's look at DX 60676, shall we? Do you recognize that document?
Yes.
What is it?
This is a document that MOS Farm Volunteer told us to send to G Club to activate our free G Club membership account.
Okay, all right. You see it up there again?
Yes.
Ms. Shrofa said, okay. Your Honor, the defense moves DX 60676 into evidence.
Mr. Finkel said, could we see the next page, please?
The court said, any additional pages?
Mr. Finkel said, could I just have a moment with Ms. Schroff?
Counsel conferring.
Ms. Shrofa said, would you show the government?
Mr. Finkel said, Your Honor, objection. We might need to approach.
The court said, okay.
Continued on next page. At the sidebar.
Mr. Finkel said, this should be a minor issue. The only objection the government has to the document is that it has her husband's name on there. If the defense redacts that, that's what I pointed out to Ms. Schroff. It's her husband's email address. Do we want to redact it? And Ms. Schroff didn't really have a verbal response. In any event, if they can redact it, I'm sure they have the technology to do that. We have no objection.
Ms. Shrofa said, Your Honor, I don't think that the email name is mentioned. It's Living Social Fixer-Upper is the email address. They didn't.
Mr. Finkel said, that's...
Ms. Shrofa said, I'm not finished, please. We got this document this way from the government. The government redacted every email address before. I just want to be able to finish this thought. Because normally, the redaction would be, I don't know, if the email address is bobsmith@gmail.com. You would take out Bob, or you would take out Smith, or you take out Bob Smith, but you leave in at Gmail.com, so at least the jury knows that somebody was copied on it, so we can say you were copied on it. The government did not redact this Living Social Fixer-Upper email address. We had no reason to think that they would object to it now, and I don't see why we should have to redact it. But if you want me to redact it, 1, it doesn't belong to her. It belongs to her husband. 2, it doesn't matter. But it will take me a minute to do it.
The court said, so let's do the redaction.
Ms. Shrofa said, okay. Do you want to give us a 5-minute break?
The court said, isn't it possible for your helper to do that?
Ms. Shrofa said, my helper is having problems with the thing keeps popping off. The computer keeps dying, but...
Mr. Finkel said, do you want to go on to something else while he's doing the redactions?
Ms. Shrofa said, no, I really don't, but it will take us 2 minutes, Your Honor.
The court said, all right. So we'll have to take a very brief break.
Mr. Finkel said, "Thank you, Your Honor."
Continued on next page. In open court.
The court said, members of the jury, we're going to take a 5-minute break. I'm going to stick to the 5 minutes. Remember, don't discuss the case amongst yourselves. Don't permit others to discuss it in your presence. Don't read, watch, or listen to anything from any source that touches upon the subject matter of this trial. We will be back in 5 minutes.
Jury not present.
The court said, ma'am, you may step out. Don't discuss your testimony.
Witness not present. Recess.
The court said, please have the jurors brought in.
Jury present.
The court said, please be seated. And the witness? You may continue.
Ms. Strofa said, so if we could show her again 60676. And the defense moves 60676 into evidence.
Mr. Finkel said, "Can I see the next page, please? And the last page?" No objection.
The court said, it is admitted.
Defendant's Exhibit 60676 received in evidence. By Ms. Schrofa.
So let's see if we can take a look at that, Ms. Chen. Could you read for us the first line?
I previously submitted a request on January 18, 2022, to activate the membership of GC Regard Order. I sent the payment on March 23, 2021.
Ms. Strofa said, and if we could scroll down to the next paragraph. Please activate the memberships accordingly. Do you see that line?
I don't. Oh, okay.
Ms. Strofa said, okay. And if we could just keep scrolling down. And then it gives the G Club's member legal name, correct?
Yes.
That's your husband, correct?
Yes.
Not you, correct?
Yes.
Ms. Strofa said, and if we could just keep scrolling down. Keep scrolling down. If we could just keep going down. And then it tells you, hold on, please, there's a ticket update time. Do you see that?
Yes.
It says, your request has been updated, correct? And then it gives you an option to add additional comments. Please reply to this email, right?
Yes.
Ms. Strofa said, okay. Keep going down. This email is a service from G Club's customer service, correct?
Yes.
Ms. Strofa said, okay. And if we could just scroll down. And that's the end of the document, correct?
Yes.
The membership is in your husband's name, correct?
Yes.
And you shared this document with we can take that down, with Mr. Finkel, right?
The email you just showed me?
Yes.
I don't remember so.
Okay. Do you talk to Mr. Finkel? You know what? I'll withdraw that. I'll come back to it later. Now, is it fair to say that there were several emails between your husband and G Clubs?
Several email?
Right. He emailed them more than once?
I think he reached out to the customer services to activate the free G Club membership that we were given.
Right. And you see Ms. Strofa said, can we bring that document back up? And if I could just show her, in summary. In summary, I have remitted. What's the dollar amount there?
100,000.
To cover these G Club orders, correct?
This is a standard language.
No. The question is, do you see the language that says G Club orders, yes or no?
Yes.
And then the next line on the next page on the same page says, please activate the memberships accordingly, correct?
Yes.
Ms. Strofa said, you can take that down. Now let's look at GXVB14.
So that's a standard language the MOS farm asked us to put in the email, as I explained earlier.
Ms. Strofa said, Your Honor, there was no question before the witness.
Because they asked for that verbiage, so I'm telling you that's not the verbiage my husband writing there. That's the verbiage MOS farm gave us the template, in order to put the template in there.
The court said, so just carefully listen to the question and answer only what's being asked. Go ahead.
Ms. Strofa said, since there was no question pending, I move to strike the outburst.
The court said, it is stricken.
Ms. Strofa said, thank you.
By Ms. Schrofa.
Let's look at GXVB 14. You provided this document to Mr. Finkel, correct?
Yes.
And you testified about this document on direct, correct?
When you say testify, meaning I said about this document yesterday?
Yes, ma'am.
I honestly don't remember if I did or not.
Okay. The memberships were active until May of 2023, correct?
Sorry. What's your question again?
The memberships
Uh-huh.
were active until May of 2023, correct?
I don't know where you see that.
It's a question for you.
I don't know.
Okay. Well, let's look. Tier 1. Active. And then it has an expiration date, correct?
Yes.
Okay. Tier 2. Active and an expiration date, correct?
Tier 2? Where do you see that, Tier 2?
I'm sorry. Row 2.
Okay.
Okay. And do you see all of them? 1, 2, 3, 4, say active, correct?
Yes.
Okay. And they were active as of May 23 until you called to cancel, correct?
Yes.
Okay. And you know, sitting here today, that Mr. Guo was arrested on March 15th. You can take that down, Jorge. Thank you. That Mr. Guo was arrested on March 15th of 2023, correct?
Yes. GXBB 16.
Ms. Shrofa said, all right. Well, let's show Ms. Chen. You see that document, ma'am?
Yes.
Okay. Do you recognize it?
Yes.
Okay. And that's Government Exhibit VB16, right? Do you see that corner little stamp over there?
Yes.
Ms. Shrofa said, okay. The defense moves to admit Government Exhibit VB16.
Mr. Finkel said, sorry, Your Honor. Just one moment. I don't think a proper foundation has been laid for this document, which is the witness's statements.
Whose email address is there on the corner?
Our joint email address.
Okay. You recognize this Gmail account, correct?
Yes.
Okay. Let's scroll down. Who attached those attachments to the email?
We attached it.
Yes. Was it you or your husband?
It's our joint email account. I don't remember in this whether it was me or he attached it.
Ms. Shrofa said, okay. I think I laid a foundation and I move to admit it, Your Honor.
Mr. Finkel said, I don't think there's a proper foundation for the witness's statements.
The court said, I think there's one additional question that needs to be asked.
By Ms. Shrofa.
Did you keep your Gmail account and send a copy to Mr. Finkel?
Did I keep?
Did you keep this email and then send it to Mr. Finkel?
I don't remember what I sent to the government. I'm sorry.
How about to the FBI agent that you emailed?
I don't remember. I'm sorry.
But you recognize this to be an email from your and your husband's joint email account, correct?
I recognize this document you put in front of me. That's an email I sent from our joint account to G Club.
Okay. You sent it, right?
We sent it together.
Ms. Shrofa said, okay. I think I've laid a foundation, Your Honor.
The court said yes. It is admitted.
Government's Exhibit VB16 received in evidence.
Ms. Shrofa said, all right. So let's take a look at it. And if we could publish it to the jury, please. Dated May 14th, 2023, correct?
Yes.
Okay. And it says, hello. I'd like to send the notice of my membership cancellation and request a refund of the 5 membership cards I paid for. Correct? Right?
You just read it.
Yes. And then you scroll down and then you say, I purchased the G Club's membership because it was marketed as an investment with stock and shares. Correct?
Yes.
And then you say you did not receive stocks or shares or any membership benefits. Right?
Yes.
It's May of 2023. And then you say it's an investment fraud, correct?
Yes.
And how many years after you first paid for this is this email sent?
You can count. I don't need to answer.
Ms. Shrofa said, Your Honor, could you help me out and direct the witness to answer the question, please?
The court said, so if you'll just answer the question that's before you, please.
Okay. Because to answer your question, I sent 2 payments, right? So which one do you want me to tell you?
Let's start with the first one. How many years between the first payment and May 14th of 2023?
Mr. Finkel said, Your Honor, I think this goes to the court's ruling, the amount of time.
The court said, I'll allow the question.
From March 2021 to May 2023, it's a little bit over 2 years.
Ms. Shrofa said, all right. Now let's take that down. And let's go to GXVB12T.
I don't see it show up yet. Don't look at me. Don't stare at me.
Ms. Shrofa said, I cannot see. I was literally going to my table to get my glasses because I cannot see that far.
The court said, okay, so no more testifying. Your job is to ask the question. Your job is to answer. That's the only thing that you should be doing respectively.
By Ms. Shrofa.
Do you see the document now?
Yes.
Okay. Do you recognize it?
Yes.
Okay. What is it?
It's the email communication with the Hamilton Opportunity Fund.
Okay. Ms. Shrofa said, Your Honor, may I just have a minute?
The court said, okay.
The witness said, the document, I don't see it.
The court said, there's no question at this time.
The witness said, okay.
Ms. Shrofa said, he's pulling it up, Your Honor. We're having a little trouble. There you go.
By Ms. Shrofa.
You recall testifying about this document yesterday, right?
Yes.
All right. Well, now you testified that did you fill out this document, by the way? Or was it your husband?
We filled out the form together.
Okay. And that form is dated June 30th, 2021, correct?
I think so.
Okay. Well, look at the date up on top. Maybe that will help you.
Yes, I said I think so.
And did you read the numbers 1 through 6 or 7 before you filled it out?
I think so.
Did you fill it out or your husband filled it out?
Mr. Finkel said, asked and answered.
The court said, sustained.
Tell me how you jointly fill out one form.
So every time when we do this type of form, want to making sure we are filling out all the information correctly, so it's either me filling out, my husband sitting next to me checking, confirming I'm filling out the correct information, or I'm the one filling out that, he's sitting next to me, confirming that we're filling out the correct information.
And who was filling out the information on this one?
I don't remember. It was a long time ago.
All right. Well, let's scroll down. And if we could look at that question there on page 6. Do you see question no? 6?
Okay. Yes, And
the question is, have you participated in the borrowing from the Himalaya New York mountains of spice? Correct?
Yes.
And you answered no, right?
Correct.
And Mr. Guo had in fact done many videos saying you should get into the borrowing from the Himalaya New York plan, correct?
I don't know.
You didn't watch his videos saying that?
I don't know how to answer your question. Sorry.
You watched all Miles Guo's videos, right?
I don't think I watched all the videos.
You didn't watch all of them, only some of them?
He had videos every day. I don't think I can watch all the videos.
Okay. Well, do you recall watching a video about the farm loan program?
I don't remember specific about the farm loan program.
Do you remember Mr. Guo encouraging you to invest in the farm loan program?
I remember Miles was said to get the GTV shares through borrowing from the farm. Participating in the farm loan program, and that is for people who are not from the old chair. Because we already part of old chair that we had GTV share, so we did not do the farm loan borrowing.
Okay, but you had GTV shares from the old chair, correct?
Yes, but Miles Guo also said participating in the.
Okay.
Yes,
Okay. Nevertheless, you invested, according to you, in G membership only to get GTV shares, correct?
Mr. Finkel said, mischaracterizes.
The court said, sustained.
And you invested in G Club membership, according to you, to get the shares, right?
Mr. Finkel said, "Objection, Judge."
The court said, "You're repeating the question. She's already answered this. Move on."
You did not invest in the farm loan program, right?
Mr. Finkel said, asked and answered.
The court said, "Sustained."
Your husband didn't invest in the farm loan program, correct? Ms. Schrofa said, "It's a different question. Did your husband invest?"
You just asked me to read this question. Did we answer no? I said no.
So your husband did not invest.
I answered already.
So the answer is no, right?
I answered it's a joint form we filled out. It's no.
The court said, "Okay."
So when Mr. Guo told you to invest in the farm loan program, you were able to say no to him, right?
Because he said to get more GTV shares through the farm loan program. We already have the GTV shares. My understanding is for those who do not have the GTV shares, that are not part of the old chair, to invest in the loan program to get the GTV shares, so that's not applied to us.
Does it say there, doesn't apply to old chair?
That's from Miles was broadcasting videos. I have explained to you.
Okay. And when Miles Guo did the broadcasting videos for G Club membership, did he also say that if you have old chair shares, don't go to G Club?
So for that video, I remember clearly that it's for old chair to gain additional GTV shares. That in order to complete that investment, pay money to the G Club accounts.
So you'd get additional shares here too, right? If you did the farm loan program, you'd get additional shares?
Mr. Finkel said, "Objection to the form. We've been through this. She's answered why she didn't invest."
The court said, "Sustained."
Let's keep going down. You said no, right?
I did not.
Mr. Finkel said, "Your Honor," 3 times. At least.
The court said, "Okay. So she's established."
Ms. Schrofa said, "It's okay, Your Honor. I'll move on."
The court said. She said no, so don't repeat the question again and again and again once you receive an answer.
All right. Page 6. We're still on page 6. Okay. And let's look at the next question. This one asked you if you participated in borrowing from other farms, and you said no, correct?
Yes.
Ms. Schrofa said, "Okay. Let's scroll down. And let's look at page 9 of the document." Now on page 9, on the top, right, it says as of September 17th. Are you planning for an additional investment? Correct? And you answered yes, right?
Yes.
What year was this document?
This document was from 2021, so, you already asked me. I filled it out on June 30th, 2021, at the very beginning.
Okay, let's scroll down. Now, Mr. Finkel asked you about 13-2, correct?
Yes.
And when you met with him in his office, you went over this question with him, right?
Yes.
And he specifically asked you whether you or your husband filled this out, right?
I don't remember that.
Did Mr. Finkel ever ask to speak to your husband?
I don't think so.
Okay, and there were 3 options here, correct?
Yes.
Okay, the first option is only to purchase G Club card. Without purchase of equities, card annual fee is required, right?
That's the English translation of.
Ma'am, I'm only asking you about the document that's before you.
So what's your question again?
You did not pick the first option, correct?
That's correct.
You did not pick the second option, which reads, only for investment. Voluntarily giving up G Club card, no card annual fee is required, correct?
Correct.
Okay. And then the third option is the option you picked. To participate in investment through card project, correct? And then it says purchase card and equities, correct, including.
That's incorrect. I explained it yesterday. The English translation was wrong.
Ma'am, listen to my question.
But you said, is it correct? I said it's incorrect.
The court said, so if you'll pose the question.
You picked option number 3 on this document. To participate in investment through card project, purchase card and equities, including upgraded card annual fee is required. Correct?
I select the option of to participate in investment through card project, distribute card and equities, including upgraded card, annual fee is required. I explained yesterday the translation here is wrong. So I cannot answer your question being that was correct, because the translation here is wrong.
Are you finished?
The court said, all right. So she has stated that she did not accept the English version here, and so that's the answer.
Ms. Shrofa said, okay. You filled out the English version, though, right?
Mr. Finkel said, objection.
The court said, overruled.
Mr. Finkel said, but...
You filled out the English version, correct?
That's incorrect. I filled out the Chinese version.
Ms. Shrofa said, okay. Well, let's scroll down.
Mr. Finkel said, Your Honor, for the record, this is a translated document that's stipulated to.
Ms. Shrofa said, that's okay.
The court said, there is a translated document so that the jurors understand. Go ahead.
Ms. Shrofa said, keep scrolling down. Scroll down.
By Ms. Shrofa.
And that's the end, right?
Yes, I guess.
Okay, let's go to the email itself. You see this email that you sent?
It's a Google response. I didn't send email to anyone.
Well, you filled out the form, right?
Mr. Finkel said, asked and answered.
You filled out the form and you uploaded it, right?
The court said, the question has been posed and the witness has answered.
And after you did this in the Chinese version of this document, you reviewed it with Mr. Finkel in English, right?
I want to make it clear on the word. I did not review this document with him.
You didn't review this document, the attachments, with Mr. Finkel?
He showed me this document. I did not review because we just talk about what is review. And review is every page, line by line. I did not do the review.
Ms. Shrofa said, let's go back to page 6 and page 9. Let's just talk about page 9. You reviewed this page with him, right?
He showed me this page.
Okay. And what did he do after he showed you the page?
So he asked me questions.
And you answered them, right?
Yes.
Okay. And you didn't have an interpreter present, right, when you talked to him about this page?
So when Mr. Finkel showed me this document, he showed me the Chinese version that I submitted and then also showed me the interpretation. The interpretation version is shown up on the screen here.
Well, it's not interpreted, right? It's translated. It's a big difference. It's not interpreted.
The court said, so the witness is not part of the translation or interpretation process and so she cannot testify about this.
Ms. Shrofa said, okay, let's move on. Sitting here today, you said to the jury that you filled out the Mandarin version, correct?
Yes, I did.
And when you received this document, did you receive it both in Mandarin and in English?
The answer is no.
You only received it in Mandarin.
That is correct.
How about the PPM? Did you receive that document both in Mandarin and in English?
I don't remember.
How about the subscription agreement? Did you receive that both in English and in Mandarin?
I don't remember.
How about the forms that you signed when you signed up for the PPM? Did you sign those in English or in Mandarin?
That's back in 2020. I don't remember.
Ms. Shrofa said, okay, we can take that down. Now you testified about an H-coin offering, correct?
Yes.
And the H-coin initial offering was in November of 2021, right?
Yes.
And you purchased H-coin, did you not?
Did you say did I not?
Did you purchase H-coin?
Yes.
Okay. And you knew. You're a citizen of the United States, right?
Yes.
And as a citizen of the United States, you're not supposed to purchase H-coin, correct?
Mr. Finkel said, objection.
The court said, you may answer.
Mr. Finkel said, calls for.
Miles Guo asked us to use the Chinese identity to open H-coin account.
Miles Guo asked you to do everything. I understand that. My question to you was,
The court said, all right. Ms. Shroff, I've already told you do not testify.
it is your testimony today, right, Ms. Chen? That every single thing you did is what Miles Guo told you to do, correct?
Mr. Finkel said, mischaracterizes.
The court said, sustained. She has never stated that in her testimony, that Miles Guo told her to do everything. No.
Did Miles Guo tell you to do everything you did in this case?
Mr. Finkel said, objection to the form.
Ms. Shrofa said, it is a question.
The court said, sustained.
What did Miles Guo tell you to do that you did not do, according to you?
The court said, sustained.
Did Miles Guo tell you to invest in GDV?
The court said, you may answer.
Miles Guo promoted the GTV to me.
I'm sorry?
He promoted the GTV investment.
Because he was GTV's promoter, correct?
Because he owned GTV, in my opinion.
I didn't ask you your opinion of whether he owns GTV, ma'am.
So that's.
Mr. Finkel said, Your Honor. I would just ask that Ms. Shroff just pose questions and not comment on the answers that the witness is providing.
The court said, Ms. Shroff.
Ms. Shrofa said, I did ask a question, Your Honor.
The court said, but you also added a comment that was not a question. Ask questions.
By Ms. Shrofa.
In each of your answers during your direct, you said you did each thing that Mr. Finkel asked you about because of Miles Guo's statements and videos, correct?
Mr. Finkel said, mischaracterizes.
The court said, sustained.
Your testimony, sitting here today, is you purchased H-Coin because of what Miles Guo said, correct?
Yes.
Okay. And at the time that Miles Guo told you, according to you, to purchase H-Coin, you were a citizen of the United States, correct?
Mr. Finkel said, asked and answered.
The court said, sustained.
And knowing that you were a citizen of the United States, you knew that you should not purchase H-Coin, correct?
Mr. Finkel said, mischaracterizes, and asked and answered.
The court said, you may answer.
Miles Guo asked me to use my Chinese identity to open and purchase H-Coin.
And you did that, right?
I did it.
And you did it only because Miles Guo asked you, right?
I did it because Miles Guo said H-Coin would go to the moon.
Okay, so there are two reasons. You did it because he said it's going to go to the moon and also because he asked you to use a certain PIN, correct?
Mr. Finkel said, object to form.
Ms. Shrofa said, I'll move on. Whose credentials did you use to open the account?
Sorry. What's your question?
Whose credentials did you use to open the account?
I answered. Miles Guo asked me to use my Chinese identity to open account.
So you used your own Chinese identity to open the account. Is that your testimony?
Yes.
Which identity did you use?
The court said, sustained.
What document did you use to open the account?
The court said, you may answer which document.
It's a Chinese ID. I said it already.
Was your Chinese ID still valid?
Mr. Finkel said, object to the relevance.
The court said, you may answer.
Yes.
And it's still valid today, correct?
Yes.
Now you testified about this phrase, H-Coin to the moon, right?
I'm sorry. Can you repeat?
You testified on direct to the phrase, H-Coin to the moon?
Yes.
Okay. And you told Mr. Finkel that you were impressed by that phrase, correct? I'll rephrase that for you. Did Mr. Guo's use of that phrase impact your decision about H-Coin?
Yes.
Okay. What price did Mr. Guo say H-Coin would rise to?
He said that it would be more valuable than Bitcoin and in the short term it will be reaching $100 very soon.
Okay. And how much was Bitcoin valued at that time?
I don't remember.
You don't remember, or do you not know?
Mr. Finkel said, objection.
The court said, sustained.
Did you know how much Bitcoin was valued at that time?
Mr. Finkel said, asked and answered.
The court said, are you asking whether at that time she knew the value?
Ms. Shrofa said, yes, Your Honor.
The court said, you may answer.
I don't remember exactly how much it is, but it was like a 10,000, like some sort of item like 50,000, or maybe 40,000.
10,000, 50,000, 40,000, right? Any of those numbers.
So it's more than, I think it's more than 40,000, yeah, maybe back then. But I don't remember exactly how much it was back in that time.
Okay. Did you know back then that Bitcoin fluctuated?
Yes.
And you talked at length with Mr. Finkel about Mr. Guo's statements about the gold reserve, correct? On Hcoin?
Yes.
Okay. Do you know if there was in fact a gold reserve?
Sorry. Can you repeat?
Do you know in fact if there was actually a gold reserve?
I trust what Miles said.
So there was a gold reserve.
Are you asking me back, then do I? I'm confused with your question. What are you trying to ask me?
Mr. Guo said there was a gold reserve, correct?
Yes.
As far as you know, there was a gold reserve, correct?
I trusted what Miles said.
Okay. So there was a gold reserve, right? Because you trusted him and there was a gold reserve.
Mr. Finkel said, asked and answered.
Ms. Shrofa said, I actually don't have an answer, Your Honor.
The court said, sustained.
Did you ask anybody on the exchange to see proof of the gold reserve?
Mr. Finkel said, Court's ruling, Your Honor. Objection.
The court said, sustained.
Let's talk about the Hcoin white paper, shall we? Do you know what that is?
It's a document.
Okay. Where is it found?
I don't remember. Somewhere on the Himalaya Exchange website.
Somewhere in the Himalaya Exchange website?
I don't remember, so I think it could be, yeah.
Did you read it?
Read it, but I don't remember what's in it.
You purchased over $500,000 worth of Hcoin, is that correct?
Sorry. Can you repeat?
You purchased more than $500,000 worth of Hcoin, correct?
I sent more than $500,000 to purchase Hcoin.
I'm sorry. Did you say I said?
I sent more than $500,000, $500,000 to purchase Hcoin.
Okay. And that was over a period of time and not all at once, correct?
Yes. I think between maybe January 2022 to February 2022, yes,
And the first time you did that, you put in $20,000, correct?
I don't remember.
You don't remember a $20,000 purchase?
Mr. Finkel said, asked and answered.
The court said, sustained.
Did you keep a note of how many investments you were making on Hcoin?
I'm sorry. I don't.
You don't what?
Don't do the thing you just asked me the question.
You don't keep a note of how much you invest.
Mr. Finkel said, asked and answered.
The court said, sustained.
Did you keep an Excel sheet?
Mr. Finkel said, cumulative.
The court said, did you keep an Excel sheet?
Of what?
Of your investments.
Of Hcoin? Of what?
Yes, of Hcoin. We're talking about Hcoin.
Like, what do you mean by keep an Excel document of Hcoin?
Make a column saying, on this day I invested $20,000 in Hcoin.
I don't.
At your first purchase, the Hcoin price was 10 cents a coin, correct? Is that correct?
That's not correct.
Okay. Well, you tell me.
I think by the time I purchased, it's more than $40 or so.
And when you purchased it when it was more than $40 or so, did you purchase it on the secondary market?
When you say secondary market, you talk about buying market, right? Yes.
Okay. And you decided to purchase at the $40 price point, correct?
I purchased because Miles said it would go to $100 very soon.
The court said, so the question was whether or not you purchased at the $40 price point.
The witness said, the question was?
The court said, she said. And you decided to purchase at the $40 price point, correct?
I decided based on the Miles was promise of going to $100, yes.
And there was a time when you purchased at a higher price point, correct?
Yes.
And you purchased Hcoin after his bankruptcy, correct?
I don't think so. I think the time I sent in the money is prior to February 15, 2022.
How about after the SEC litigation or before?
What SEC litigation you're referring to?
The SEC litigation you referred to yesterday.
The SE, about the GTV that was not proper registered or something? Is that what?
Exactly.
I think that's after that one,
So your purchase was after that, correct?
My purchase is in January 2022, and then I think that SEC thing happened before that, yes,
Okay. So SEC said to this man, you didn't do something correctly. And you decide to listen to him and buy H coin, correct?
Mr. Finkel said, object to form, and the court's ruling.
The court said, sustained.
How many months after the SEC litigation did you buy H coin?
Mr. Finkel said, same objection.
The court said, sustained.
You had an initial allotment of H coin purchase based on the 10 cents price, correct?
I was allocated a quota of certain H coin at 10 cents per coin, and I paid for it. But I never had those coins.
Can you try, Ms. Chen, to listen to my question, please?
The court said, okay. So I'd like the parties to step up, please.
Continued on next page. At the sidebar.
The court said, so Ms. Schroff, you said. So SEC said to this man, you didn't do something correctly. And you decide to listen to him and buy H coin, correct? That's exactly crossing the line at this point.
Ms. Schroff said, that's the direct that they elicited, Your Honor. I'm not seeking to touch a topic they didn't bring out. They brought out the SEC litigation. Those were her words on direct, that he broke some regulatory rules. So I was literally trying to follow exactly what she had said in her direct to limit my scope to what was said in the direct. So not to go beyond that. That is all I was trying to do. Simply a matter of timing is what I was trying to show. That's it.
The court said, no. I think you're trying to show that despite what would have been an obvious warning that this is an extremely risky investment, she decided to do it anyway. That is what I think you're getting at.
Ms. Schroff said, I wasn't trying to get at that. I'm trying to show the timing. And I've repeatedly tried to show the timing because I put in the timing of the bankruptcy. I put in the timing of when she did the first allotment and when she subsequently buys on the secondary market.
The court said, so if you want to show timing, then you ask for dates. You don't say, essentially, the SEC warned you but you did it anyway. You ask for dates.
Ms. Schroff said, I didn't say SEC warned her. She said the SEC warned her. She said the SEC made a finding that he broke the regulatory rules. She testified to that yesterday.
Mr. Finkel said, she did not testify to that yesterday.
Ms. Schroff said, you are free to reread the transcript. She said the SEC fined him for breaking some regulatory rules. That's her testimony.
The court said, so what you need to do is ask for dates.
Ms. Schroff said, okay.
Continued on next page. In open court. By Ms. Schroff.
I'm going to come back to this topic in a minute. But I'm going to switch gears for a minute and talk to you about your volunteer work, okay? Now, Ms. Chen, you wanted to volunteer for the Mountains of Spice Farm, correct?
Yes.
Okay. And you first wanted to volunteer, you said yesterday, in 2022, correct?
Yes.
That was your testimony yesterday? In fact, you first reached out to volunteer in 2021. Do you remember that?
I remember I joined a group within the MOS farm and expressed my interest to volunteer.
Well, you didn't just express your interest to volunteer, you told them why you would be a good volunteer. Correct?
I don't remember. I think they have some specific things you have to explain to them before I could volunteer. Request that type of thing.
Well, let's see if we can refresh your recollection by showing you Defense Exhibit number 7014. Yesterday you said your first volunteer was in 2022, but today you agree it was in 2021, correct?
So I said in 2021 I started to express my interest, but I think my real volunteer work started in March 2022. Like truly doing something that is doing the true volunteer. Well, I started reaching out to express interest in 2021, and then, here, end of 2021, yeah.
Let's just go through the chronology together, okay? In December of 2021, you approached. Who did you approach? Do you remember?
I'm sure they were here.
I don't want you to look at the document. I just showed it to you to refresh your recollection about the date.
Mr. Finkel said, should we take down the document if the recollection has been refreshed?
The court said, you're showing the document now?
Ms. Schrofa said, well, the witness had testified, you know what, I'll come back to the document. I'll come back to the document.
By Ms. Schrofa.
You now remember, right, that it was in December of 2021, correct?
I think I mentioned to you, I expressed interest of doing the volunteer work.
Okay. And that was about December, early December, right? By December 9th, maybe?
I did not remember that, but since you just showed me the document, the date is there, yes.
Okay. And in December 9th, you reached out to a particular group of Mountains of Spice, correct? Do you remember that?
I reached out to a group. I don't know why you say a particular group.
What's the name of the group?
I think that was something related to the finance group.
All right. And you reached out to them and you told them what your qualifications were, correct?
I think that's their requirement. Before you express interest, talk about the volunteer work. You like to participate, they ask you to provide some background so that they know you, who you are. And see what other volunteer work that can be there that will be suitable based on your experiences.
And what was your experiences that were suitable for that volunteer work?
You already said I work in a bank.
Ms. Chen.
I work in a bank. I work in a bank.
What else did you tell them? Do you remember?
I don't remember.
Ms. Schrofa said, all right. Well, let's show her again DX 7014. Take a look at the column on the right.
Mr. Finkel said, what's the question?
The court said, we're waiting for the question.
Are you finished reading, Ms. Chen?
Yes.
Okay. Does that refresh your recollection as to what it is that you told them your qualifications were?
Yeah, that is what I said. It gave you a template, you have to explain your experiences. And that's what I filled out, based on the template they're giving us.
Where's the template in this document?
Mr. Finkel said, the document is not in evidence.
Ms. Schrofa said, okay. Well, let's see. Is that your handle over there in the corner?
My handle?
Yes. Who's there on the photo on the left side?
When you say handle.
Who is Ivy Ivy?
That's a nickname I used when I register in the MOS farm.
And this is all your document, correct?
Yeah, this is my communication.
Ms. Schrofa said, let's just keep scrolling down. Scroll down some more. Do you recognize this document?
Yes.
Ms. Schrofa said, okay. Let's keep scrolling down. And you recognize page 2 of this document, correct?
I don't remember this one.
Okay. Well, let's go down to page 3. Who is Alwell?
That's a nickname my husband used.
Okay. And the page 2, do you recognize who you're talking about when I say my husband Alwell?
I recognize my husband. You mean I recognize my husband nickname? Yes,
Okay. And you're on Discord, correct? Having these chats?
Yes.
Ms. Schrofa said, okay. I moved DX 7014 into evidence.
Mr. Finkel said, Your Honor, may I ask a question or two?
The court said, yes, you may.
Voir dire examination. By Mr. Finkel.
Ms. Chen, these chats that you had, were they in Mandarin or in English?
In Mandarin.
And this English language on the side, did you write it?
No.
Do you know where that's from?
I don't know.
Do you know if it's right?
I don't know.
Mr. Finkel said, we object, and if necessary, a sidebar may be appropriate.
Ms. Schrofa said, Your Honor, may I just ask her a few questions?
The court said yes. Go ahead and ask a few questions.
By Ms. Schrofa.
You read Mandarin?
Yes.
Do you read English?
Yes.
Ms. Schrofa said, We moved DX 7014 into evidence.
The court said, so the question is whether or not the translation, in her opinion, accurately reflects what was written in Mandarin.
Ms. Shrofa said, I'm happy not to question her about any of the English language.
Mr. Finkel said, maybe we can approach.
The court said, so let's approach.
Continued on next page. At the sidebar.
Mr. Finkel said, there are a few reasons why this is objectionable. The first is, we received these documents at 9:56 a.m. this morning, which is when this witness was on stand. There's no stipulated translations for this document at all. While the parties have had good conversations and have reached stipulations on most Mandarin language issues, that has taken time. The government experts have reviewed their proposals. Their experts have reviewed our proposals. We've been able to reach an accommodation. The court has been consistent throughout this trial that Mandarin language that's not translated cannot be admitted. We would have preferred to put in a variety of documents that were in Mandarin that we ourselves translated. But have set a stip, we didn't do that. So that's number one is, this is a Mandarin language document which she has not had time to review the accuracy of the English translations. Nor could she, as Ms. Schroff in fact objected yesterday. She's not a 702 witness who is qualified to render an opinion about whether the English language is correct from the Mandarin. That's the simplest way to deal with this document. Number 2, she didn't authenticate page 2. She doesn't recognize it. Number 3, these are statements of the witness, so they're hearsay. And they're not inconsistent with anything she has said, so that's not a reason. And to the extent her memory needs to be refreshed, she can be shown this document. I didn't object to that. But we can't introduce it as an exhibit because of the Mandarin language. Because it's her statements and there's no proper basis. 3, I don't really understand the relevance. But maybe there is relevance. So those are the primary reasons.
The court said, are you looking to impeach her with this?
Ms. Shrofa said, I was actually looking to put it in as well, but I will certainly use it to impeach her, number 1. Number 2, yesterday, when she testified as to her translation and her understanding of the Mandarin document. And again today, her understanding and her position that it wasn't accurately translated was in fact allowed. Mr. Finkel objected to my objection. And the court allowed the testimony to stand that she was of the opinion that the translation of that document was incorrect.
Mr. Finkel said, that's not correct.
Ms. Shrofa said, I haven't even finished.
Mr. Finkel said, I thought you had.
Ms. Shrofa said, so the record is just out there. And the court actually said she disagrees as to whether or not the translation is accurate. I think that happened today.
The court said, so just going backwards, if they have not had a chance to have their translators review it, then it cannot come in. You can certainly use it to try to impeach her by showing it to only her.
Ms. Shrofa said, okay.
The court said, okay.
Continued on next page. In open court.
The court said, you may continue.
By Ms. Shrofa.
In December of 2021, you were on Discord, correct?
Yes.
And on Discord, you sought to join the finance group because you wanted to volunteer in that particular group, correct?
I joined a group, sorry. What's your question? I joined a group because I want to volunteer?
In the finance group specifically, yes.
I joined the group, but not because I want to volunteer specifically in that group. I just joined the group.
Okay. Well, you told the group why you would be a particularly good person in that group, correct?
I explained earlier, they ask you to provide your background, so I provided my background.
Well, you did more than that, right? You told them you were eager to join the farm's finance department, correct?
Where did you see that?
Mr. Finkel said, so this.
The court said, so.
Ms. Shrofa said, the document shouldn't be in front of her. My question to you is, do you recall telling them on Discord that you were eager to join our farm's finance department to contribute my modest efforts? Do you recall saying that on Discord?
I don't remember that.
Let's show you again 7014.
The court said, and so you don't have to read from the document. The only question would be, does that help you remember? Does that refresh your recollection?
I don't remember I said that.
Just take a minute and read the document, and just the only question, as the judge said, was.
The court said, the Mandarin version, if that is the language in which she was.
Ms. Shrofa said, sure. There you go. It's right there on the left column.
So you ask me, so I think I said I joined the group, but not because I want to contribute in that group.
That wasn't the question, Ms. Chen. The question, maybe the judge can repeat it.
The court said, so the question is, does this help refresh your recollection as to what you said?
And what did I say?
That you were eager to join the farm's finance department. Eager to join.
I think, okay, when I say eager to join, it's.
The question only is whether you said that.
The court said no. The question is whether this document refreshes her recollection. That's the first question.
I don't remember.
Okay. And do you recall then telling them why you would be particularly suited to the finance department?
Mr. Finkel said, asked and answered.
The court said, sustained.
Did you list your skills as to why you would be particularly suited to the finance department?
Mr. Finkel said, asked and answered 3 times.
The court said, sustained.
Ms. Shrofa said, I did not ask that question, Your Honor.
I explained, asked me to.
The court said, so the objection is sustained, so don't answer.
What were the skills that you listed?
Mr. Finkel said, asked and answered.
Ms. Shrofa said, I did not ask that question.
The court said, if you have a recollection, do you recollect?
The witness said, I don't.
Do you recall saying to them that you had skills in English, financial management, risk analysis, credit, legal compliance, auditing, business process organization, certified public accountant, certified internal auditor, education, MBA, over 10 years of experience at large financial companies in the U.S.?
Mr. Finkel said, objection, because Ms. Schroff is reading from a document that is not in evidence.
Ms. Shrofa said, I'm asking her if she listed those things.
I don't remember. I answered your question.
All right.
Already.
I'll show you again the same document to see if the document refreshes your recollection as to the last question.
The court said, the objection was overruled. Go ahead.
Ms. Shrofa said, show her the Mandarin language, please.
I don't remember.
Okay, let's move forward. Do you recall also on Discord telling, oh, let me go back to the question you were talking to?
The court said, so it's now 11:30, so we're going to take our half-hour break. Members of the jury, remember, don't discuss the case amongst yourselves or with anyone else. Don't permit anyone to discuss the case in your presence. Don't read, listen to, or watch anything that touches on the subject matter of this case.
Jury not present.
The court said, ma'am, you may step out of the courtroom. Don't discuss your testimony.
Witness not present.
The court said, is there anything before we reconvene?
Mr. Finkel said, Your Honor, I'd just like to understand how much more Ms. Schroff has. She's now had cross-examination for 3 hours. Ms. Chen was on direct for 1 hour and 10 minutes. The government's point of view is most of this is entirely irrelevant. But it would just be helpful to know. Because we have one more witness. We're trying to figure it out. We'd like to rest today. We were hoping to rest 2 days ago. I don't know if this is a filibuster to prevent the defense from having to present their case until Tuesday. But we're way far afield from scope and relevance and a host of other issues.
The court said, Ms. Schroff, how much more?
Ms. Shrofa said, Your Honor, this is well within the scope. Did the court want me to address that issue or no?
The court said, I want you to address the timing.
Ms. Shrofa said, I think about 45 minutes.
The court said, 45 minutes?
Ms. Shrofa said, Yes, Your Honor.
The court said, I'd like you to cut that back.
Ms. Shrofa said, "We tried."
The court said, "I'd like you to cut it back."
Ms. Shrofa said, "I will definitely try, Your Honor."
Mr. Finkel said, "Your Honor, may I just raise one other issue?"
The court said yes.
Mr. Finkel said, "Just further to what was discussed at sidebar. The question that Ms. Schroff posed about the timing of the SEC settlement and her decision to invest after the SEC said, as Ms. Schroff put it, in effect, SEC said Mr. Guo did something wrong, you still decided to invest. There's only one possible inference to draw from such a question, and that is that Ms. Schroff is suggesting to the jury that Ms. Chen, who she has emphasized many times over and over, was involved in risk management at a bank. Ms. Schroff's point is, Ms. Chen should have known better. That's the only point to draw, and all right. I don't want to."
The court said, "So the date that I'm referring to is the date that she decided to make the investment. Ms. Schroff can raise, or whoever is going to do the summation can raise, the date of the SEC warning or statement, but not in a question to the witness are you to raise the SEC issue. Just the issue of when she actually made the investment, in other words, not to draw the jury's attention to the timing of the SEC's statement and the timing of her investment."
Mr. Finkel said, "Yes, Your Honor. I agree with that. And the government's concern, and we've articulated this in other instances. I think this is the best example of it, is the jury thinks, or we're concerned the jury might think, and certainly can be confused to think, that if the victims are negligent or unsophisticated or didn't do enough research. There was another question posed. Did you reach out to Himalaya Exchange to ask if they had gold? Your Honor sustained that. The question in this trial for this jury is whether Miles Guo had intent to defraud. The intent and sophistication of the victims is not relevant. And I really feel, the government feels, that the jury is confused. And we'd ask Your Honor to consider giving an instruction, which is a correct statement of the law, so that there will be no confusion, and because the defense has never objected to the fact of that instruction as a practical statement of the law, we think it's appropriate."
Ms. Shrofa said, "Your Honor, under Litvak, I'm entitled to show what information this witness had access to. I reread Litvak. I consulted with the person who has a deeper understanding of it, and I believe the questions I asked were permissible. More importantly, this jury does not seem in the least bit confused. It seems like a very sophisticated, enthralled, and attention-paying jury. And finally, Your Honor, I am quite certain that the court's jury instructions, which will come after, I'm assuming, a day or 2 days break, this witness, we hope, will be a very distant memory for all of us. So for those reasons, Your Honor, I do not think any instruction at this point is needed."
Mr. Finkel said, "May I respond?"
The court said yes.
Mr. Finkel said, "So, Your Honor, after this witness, which I guess has another 45 minutes. So she'll be on the stand for 4 hours, in which she has been crossed extensively about what she knew, when she knew it, what research she did, and she's not the first witness to experience this. They're going to have a defense case, which is going to be filled with information from the white paper and all kinds of other things, all to suggest to the jury that they should have known better. And Ms. Schroff's right. I think the jury is very attentive, but we don't know what they're thinking about what they need to decide. And as they're taking this information in, given the 2 questions, there were several, but the 2 in particular that I referenced. Did you call the Himalaya Exchange and ask if they had gold? That's not Litvak. That's suggesting she should have made a phone call to the Himalaya Exchange and researched it. And then she did the same thing. And did you have Google? Do you have Google? And Ms. Chen said, yes. Of course I have Google. These are suggesting the victim should have done more. This is not a mix of information. An instruction here is appropriate.
The court said, "So I don't know that you're right. If you can provide some appellate authority that an instruction at this moment would be appropriate, I would look at it. We'll start again at noon.
Mr. Finkel said, "Yes, Your Honor."
Recess. Afternoon session 12:06 p.m.
The court said, "Please be seated. I just received news that juror number 8 just received news that his daughter has tested positive for COVID. I have sent back a mask which number 8 has put on and we will just proceed from here."
Mr. Kamraju said, "Your Honor, can I just note one thing since we're talking about jurors? I believe alternate number 4 this morning when I was riding up on the elevator approached me and asked if he could get on the elevator with me. I said no, why don't you take this one, and I conferred with government counsel. I don't think there's anything to be done. I just wanted to let Your Honor know."
Mr. Finkel said, "That's fine from the government's perspective. Your Honor." The government emailed Chambers a copy of Second Circuit authority regarding the issue we discussed before the break. Happy to answer any questions if the court has any. The government's view is that this case is on all fours with the situation that is before the court right now. In that case, the defendant disclaimed a duress defense, then testimony elicited information about threats. The government objected on the basis it appears that such threat information was confusing the jury about the appropriateness of that information. And the court mid-trial Judge Rakoff provided a corrective instruction mid-trial and post-trial. Second Circuit affirmed both instructions. We think both are appropriate here so that the jury is not confused, and that the court deliver what is unobjectionably a correct statement of the law. And that's all the Second Circuit would review, is whether the statement Your Honor makes is a correct statement of the law, and based on the responses to the proposed jury charge. I don't believe that the defense has objected to the statement in the proposed jury charge that the sophistication of the jurors is not what is relevant to this trial, and they are not under any obligation to discover the fraud.
Mr. Kamraju said, "Your Honor, I think, 1, there's a difference between a duress defense, which is obviously a defense that the defendant has to notify the government and the court of before. My understanding is Ms. Schroff's questions were targeted towards the access to the information. And Your Honor did rule that sophistication is a factor that the jury can consider under Litvak. I'm not sure that any kind of instruction is appropriate now. And I'm not sure that Peterson actually speaks to the appropriateness of it in this context."
Mr. Finkel said, not to go down this path again, but Ms. Schroff asked the witness, "Did you call the Himalaya exchange and ask them if they had gold?" Suggesting, did you do research to determine that there was no gold? She also asked, "Did you know that Miles Guo was told by the SEC that he did an unregistered security offering on this date? And then after that date you invested again?" This is saying that there were red flags, which there were. There were red flags for this victim, but there's no reliance. It's a question of Miles Guo's intent, not their intent, and the jury is confused about this issue. This Second Circuit authority provides basis for the court to provide a mid-trial instruction in such circumstances. Your Honor noticed this sua sponte and called for a sidebar in response to Ms. Schroff's question about the timing of the SEC investment. This is not about access to information. They have done it through Ms. Chen. They have done it through other witnesses. They have tried to lay sort of subtext that the victim should have known.
The court said, "So I don't agree that it's appropriate to give the instruction at this time. So let's have the jurors brought in."
Continued on next page.
The law clerk said, "Jury entering."
Jury present.
The court said, "Please be seated. Members of the jury, juror number 8 has informed the court that his daughter was just diagnosed with COVID, and I directed that he wear a mask, and so I want all of you to be very mindful of your health as we go along. And if you should be diagnosed with COVID, I'd like you to text the 3 numbers that we will be giving to you at the break. Alrighty, you may continue."
By Ms. Schroff.
Ms. Chen, in early December of 2021, you also on behalf of your husband asked for the opportunity for him to volunteer, correct?
I don't remember that.
Do you recall? Okay. Let me show you again the same document to refresh your recollection. 704. And if I could show her the Mandarin version, please, and the English version as well, whichever one she picks.
I don't remember I did.
Thank you. And did there come a time when both you and your husband were volunteering for Faith Night? Correct?
We're not volunteering for Faith Night, no.
You were volunteering in her group, correct?
I volunteering MOS Farm.
My question was, she ran the finance group, correct?
I'm not sure.
Well, didn't she tell you that you were welcome?
I don't remember.
All right. Let's go back to the document again. Does that document refresh your recollection that you in fact approached Faith Night? And she is the one who said you and he are welcome?
Mr. Finkel said, "That's not the question that was asked."
Ms. Schrofa said, "I'm happy to rephrase. Let me try the first question again. Do you recall asking or directing your Discord chat to Faith Night?"
I recall I expressed interest to join a group.
Right. And the group leader at that time was Faith Night, right?
I don't remember.
Well, does that refresh your recollection, the document?
I don't remember.
The document that's on the screen?
I don't remember.
The court said, so if you'll look at the document on the screen and then say whether or not that refreshes your recollection.
I have looked at this document and I said I don't remember.
And you also don't remember whether it was Faith Night who welcomed you, correct?
Mr. Finkel said, asked and answered.
The court said, overruled. You may answer if you remember that.
I don't remember. There are like different volunteers in MOS Farm. I reach out to someone first and tell us to provide the template. And then we follow the template and reach out to another person, so I don't remember who is who.
Sitting here today, you do know who Faith Night is, right?
I do.
And let's move forward. Did you also know somebody named Octopus who was in the same finance group in December of 2021?
I don't remember.
And in December of 2021, you were aware, were you not, that Mr. Guo rewarded people who volunteered, correct?
I was not aware.
And you were not aware that Mr. Guo had produced videos and talked about the benefits of volunteering at a farm?
I don't think I recall.
There did come a point when they accepted you into the group, right? In December of 2021?
I think so.
And do you remember that was on December 9th of 2021?
I don't remember.
And do you remember saying to them that you were happy to be a volunteer and called it our finance group?
I don't remember.
Do you recall telling them that your husband had experience in finance and fintech?
I don't remember.
May we show her again the same document?
I don't remember.
We can take that down. And do you recall telling them about his extensive IT experience?
I don't recall.
And this is still in December of 2021. Do you recall that you started volunteering in December? Do you recall that?
I don't recall.
Do you recall that in December, on December 20th of 2021, you stopped volunteering? Do you recall that?
I don't recall.
Do you recall that your husband also stopped volunteering on December 20th of 2021?
I don't recall.
Now moving on to February of 2022, you were working at that time, correct?
When you say I working, can you help clarify?
Sure. First you were just working as a mother, correct?
No, I'm always working.
Mothering is work. I'm asking you. That's work. I'm acknowledging your work.
Mr. Finkel said, objection to the commentary.
Ms. Schrofa said, I'm trying to answer her question.
The court said, just ask the questions.
You worked at home, correct?
No, I always have a job. I don't understand what's your question. When you say work, can you help me understand? When you say work as a mom, what does that mean?
You looked after your child. You fed your child. You put him to bed, he, she, your children. You took care of them, right?
Mr. Finkel said, relevance objection.
Ms. Schrofa said, I'm literally trying to do what the witness asked.
The court said, overruled. What's the question?
What's the question?
You had a full-time, correct?
Yes.
And then you worked at home also, correct?
When you say I work at home, meaning I take care of my kids at home?
Yes, that's work.
Yes.
Okay. And that was in February of 2022 as well, correct?
That's all the time when I have kids, I do that type of job.
And in February 2022, it was COVID time, was it? Do you remember?
Yes.
And at that time, were you actually physically going to work at that time during COVID?
I work remote.
And how long do you recall working remote?
Mr. Finkel said. Relevance objection.
Ms. Shrofa said, I'll move on, Your Honor. I'll move forward. It's okay. As part of your volunteer work in 2022, were you a volunteer?
Yes.
And you testified on direct, right, that you were working 10 hours at volunteering, correct?
What do you mean by 10 hours?
How many hours did you volunteer?
I testify on average I volunteer about 40 hours per week.
So on arrange you know what? I won't repeat it. And at this time you were also working remotely 40-hour weeks?
Yes, that's correct.
And there came a time when you had to submit timesheets for your volunteer work, right?
Yes.
And do you recall sitting here today that you submitted timesheets for 2,390 hours?
Me alone?
Yes,
The court said. Covering what period?
Ms. Shrofa said. I didn't hear.
The court said. 2,000 hours covering what period of time?
Ms. Shrofa said. For February.
The court said. For February alone?
Ms. Shrofa said. I'll see how she put it. You submitted timesheets to Discord, correct?
Yes.
And your Discord hours you noted as daily average working hours were 10, correct?
So my testimony talk about an average hours 40 hours between March 2022 and March 2023. So I work more hours during the period of March 2022 till September 2022, and less hours from September 2022 till March 2023. So by the time you say about 10 hours a day, that was during the time that I was working between March 2022 till September 2022.
Actually, it was February of 2022 to October of 2022, correct?
So maybe my recollection has a month off or so, but if you say that.
To be precise, it's February 26th of 2022 to October 22nd of 2022.
Okay. If you say February 26th, 2022, it's close to March, yeah. It's close to March, yes. So it's a few days off between you say starting on February 26th versus I say March 2022.
And that's all through COVID, right? March was COVID, right?
Yes.
April was COVID, right?
Mr. Finkel said. Objection to the relevance. What are we doing?
The court said. Sustained.
You were working remotely during that time, correct?
Mr. Finkel said. Asked and answered.
The court said. Sustained.
You submitted these timesheets, right?
Mr. Finkel said. Asked and answered.
The court said. Sustained.
Who did you submit it to?
You said Discord. If that is true, I submit in Discord. I don't remember who I submitted it to.
And somebody in Discord contacted you about your timesheets, correct?
I don't remember.
They told you these were exaggerated timesheets, correct?
Sorry. What's your question?
They said you had inflated your timesheets, correct?
I don't recall that.
You don't recall them saying you couldn't possibly have put in all of those hours?
Mr. Finkel said. Asked and answered.
The court said. Sustained. Asked and answered.
You were in fact asked to describe what work you did as a volunteer, correct?
I think so.
Right. And you provided a description, correct?
I think so.
And they took issue with your description of the work you provided, correct?
They took an issue with?
They disagreed with you, correct?
I don't recall that.
And then did there come a time when you also stopped volunteering again?
There come a time that I stopped volunteering or started up.
Stopped.
I answered, March 2023.
And you stopped because the people in your group pushed back on your hours, correct?
That's incorrect.
So why did you stop?
Why did I stop?
Yes.
Back then, my parents' their house were not doing very well. So I planned to take a step back and spend more time with them.
But that was in December of 2021, right? That's what you told the people on Discord in December of 2021?
That's what I told them in March of 2023.
Let me show you again this same document exhibit. Actually, I'll move on. When you decided to stop volunteering, did you tell anyone over Discord the reason why you stopped?
I messaged Octopus through the WhatsApp chat on March 2023.
But you and Octopus did not get along, correct?
I don't understand when you say do not get along. What does that mean?
Because you and Octopus and you and Faith Knight and you and Fei Fei had a disagreement about how you were calculating your volunteer hours and how they related to your H-coin allotment. Correct?
Mr. Finkel said, form objection.
That's incorrect.
The court said, overruled.
Let's look at your H-coin allotment, okay? You agree with me that the initial H-coin allotment was based on several factors, correct?
You didn't say what those factors are. You said it's based on several factors.
You know they were based on several factors. Do you know that or not?
Can you tell me those factors so I can answer your question yes or no?
Sure. One of the factors was the amount of volunteer work done, correct?
So the H-coin allotment was provided before H-coin launched in November 2021. So the volunteer work calculated is for the volunteer work done before November 1st, 2021. So back then, I did not even volunteer. So it's not have anything to do with my H-coin allotment.
We'll get there. I'm just talking about the initial allotment. Okay. The initial allotment you knew was based on volunteer work, correct?
I did not know.
How about did it depend on how much money you had invested?
That's what I know.
And then wasn't it also multiplied by a certain coefficient, correct? There was a formula that they used, correct?
Yes.
And the formula was either 0.5, 0.7, or 0.02, correct?
Yes.
And when you were doing the calculation for yourself, there was a disagreement about your particular calculation, correct?
Mr. Finkel said, asked and answered.
The court said, sustained.
Ms. Strofa said, I have not even touched the November portion of this allotment.
The court said, you've asked that question generally. Are you asking it with regard to a specific time?
Ms. Strofa said, yes, Your Honor. I'm asking it about the time frame that the witness just referred to, which was the pre-period when it was calculated before H-coin was offered.
The court said, okay. You may answer.
So what's the question?
There was a disagreement as to your actual calculation, correct?
I have explained in my testimony yesterday, my investment got miscounted in H-coin allotment.
You believed it was miscounted and they did not agree with you, correct?
When you say they, who are you referring to?
The people who were in charge of allotments, they did not agree with you, correct?
Who were in charge of the H-coin allotment?
You tell me.
I don't know.
Well, they told you that they disagreed with your calculation?
Who told you they disagree with my calculation?
Ms. Chen.
I don't know who she's referring to, so I cannot answer her question. She told me they. But she didn't tell me who is they.
The court said, Ms. Schroff.
You did the calculation at a 0.7 rate, correct?
I didn't do the calculation at 0.7 rate. It was provided to me at 0.7 rate because I think they said the coin is gone, so I have no choice of doing the coin. I can only do the fund, and the fund is 0.7.
They told you specifically that your calculation should have been at the 0.2 rate, correct?
Mr. Finkel said, we've been through this.
The court said, you may answer.
I don't recall that.
Now, Ms. Chen, you are an active trader on the Himalaya exchange. Is that correct?
I'm not saying I'm active trader, but I do sell and buy because the price drops so much. So when it kind of get to the point it's just so low, I don't know what to do, so I do sell.
You had 90 buy transactions since the opening of your account, correct?
I don't remember that amount.
You made 80 sale transactions, correct?
I don't remember.
You were playing on the H coin market to see if you could make a profit, correct?
That's incorrect.
What did you trade for if not to make a profit?
Incur as much as I can.
I'm sorry.
Have as much as I can.
Same thing, right?
It's different.
All told, you had 80 buys and 90 sales transactions, right?
I don't remember.
Well, you have access to your sales and your buys, right?
I haven't logged an account for a long time.
I didn't ask if you had logged in for a long time. My question was whether you had access to that information.
Yes.
By the way, did you and Mr. Finkel over there access this information to prepare for your testimony today?
No. The answer is no.
Ms. Chen, you testified on direct that you took a second loan on your home to purchase additional GTV shares, correct?
Yes.
That was in December of 2021, is that right?
That's incorrect.
Well, you tell me the correct date?
I think yesterday I said it's the Crane Advisory. That was in March of 2021.
You think you took your second home loan in March of 2021? I just want to get the month right.
Mr. Finkel said, objection. I think it's mischaracterizing what was just said.
I'll ask the question again. In what month did you take your second loan on your home to purchase additional GTV shares?
Mr. Finkel said, objection to form. Year 2, right?
The court said, put in the year, please.
2021?
Mr. Finkel said, objection to the testimony. Ms. Schroff can ask the question.
Ms. Schrofa said, you told me to put a year.
The court said, so the month and the date that you're asking about, Ms. Schroff.
Ms. Schrofa said, I'm asking her what month and date she took the loan out. I'm asking her the question.
The court said, okay, you may answer.
If I remember correctly, I think it's March 2021.
And at that time in March of 2021, you also owned a townhouse in Falls Church, Virginia, correct?
Mr. Finkel said, objection to the relevance.
The court said, does this have to do with the home equity loan?
Ms. Schrofa said, no, this is her other assets.
Mr. Finkel said, highly irrelevant.
The court said, sustained.
But you had other assets, right?
Mr. Finkel said, same objection.
The court said, sustained.
Did you invest in real estate, Ms. Chen?
Mr. Finkel said, same objection.
The court said, sustained.
Ms. Schrofa said, Your Honor, may we have a sidebar?
Mr. Finkel said, I don't think one is needed.
The court said, okay.
Continued on next page. At the sidebar.
Ms. Schrofa said, Your Honor, the jury is left with an impression that she took a second loan on her home. And as a result of that, there should be some sort of sympathetic reaction to somebody taking a second loan. The same person can take a second loan on a home because it seems like a financially astute thing to do or a financially solvent thing to do. I think it's fair for the jury to know that she had options, and she was an investor in real estate. She actually leased out and rented out these properties. And all told, she had 9 properties in the state of Virginia. It simply goes to take away that sympathy factor that the government created by asking how and why she took a second loan so she could buy GTV shares.
The court said, I think the government is merely establishing that she used these funds to make a purchase and that she was defrauded. Not that the jury should feel sympathy. The prosecution is using this for a finding of fraud.
Ms. Schrofa said, but a second loan on an apartment wouldn't be irrelevant. It's her money.
The court said, the question of how she made the payment is relevant, but whether or not she has other types of investment, I don't agree is relevant, so let's move on.
Continued on next page. In open court, jury present. By Ms. Schrofa.
Ms. Chen, on direct examination you recall testifying about the email you sent about the Hamilton Fund. Correct?
Sorry. I missed part of the question. Can you repeat?
You testified on direct about emails you sent to Mr. Fallon, correct?
So you mean I emailed Mr. Fallon, right? That's your question? You said I testified I emailed Mr. Fallon?
Yes.
Yes, I email him.
And you emailed him and your husband also emailed him, correct?
Let me put this way, we emailed Mr. Fallon.
And you testified on direct that Mr. Fallon didn't reply but sent you to a lawyer, correct?
I testify Mr. Fallon didn't respond and then his lawyer responded.
And the lawyer told you that the funds you were seeking return of were frozen, correct?
Mr. Finkel said, objection, hearsay.
Ms. Schrofa said, it's not being offered for the truth.
The court said, I'll allow the question.
What's the question?
He told you the funds were frozen, correct?
He told me my money was frozen, yes.
And you disagreed, right?
Right.
And you kept emailing that the funds were not frozen, correct?
I explain it.
And they disagreed with you, correct?
They saying the same thing, my money was frozen.
And at the same time that you were emailing Mr. Fallon and his lawyer, you were also emailing the Department of Justice, correct?
I don't think, when you say emailing, what do you mean emailing?
In May of 2023, you were in touch with the United States Attorney's Office, right?
I do not think so.
Well, let me see. You don't think you were in touch with the United States Attorney's Office. These prosecutors in May of 2023?
So I follow the website on DOJ, where they have a link to submit victim information. So I filled out information following that link. And at the same time, they have an email address that I email them letting them know that I completed information. In addition, that form does not include a specific investment item I have. So therefore, I'm including that specific investment item in the email that I sent to the victim mailbox.
And Mr. Finkel works for the Department of Justice, right?
I actually don't know. I guess yes. I don't know.
Who do you think he works for?
I don't know.
Do you think he works for Mr. Guo?
No.
So who do you think he works for?
He works for the government.
Okay. And that's the email address you emailed, right? In May of 2023, right?
I email one that is available on the DOJ website. It's victim mailbox, specifically just for the victim.
And then after that you followed up by sending emails to the FBI, right?
No, I did not.
Let's show you 3602 to 26. Does that refresh your recollection that in June of 2023 you met with FBI D. Marino?
Mr. Finkel said, objection. The question was about May, not June.
Ms. Schrofa said, I was off by a month. June of 2023. Did you meet with the FBI agent?
So you're asking me my recollection, asking me to read this document?
I'm just asking you if you met with the FBI Mr. D. Marino. Do you remember?
Someone reached out to me from FBI and I met them. To answer your question, I did not email FBI. So I sent the email to the victim mailbox and then FBI reached out to me and scheduled a meeting.
After he reached out to you, you emailed back and forth with the FBI agent, correct?
I don't know when you say email back and forth.
Which FBI did you email yesterday?
You just want to know the name?
Yes.
I emailed yesterday. I didn't email any FBI yesterday.
When is the last time you emailed an FBI agent?
Don't remember.
Did you text an FBI agent yesterday?
You just asked me the name of my FBI agent, right?
Yes.
You want me to tell the name now?
Yes.
It's Nick.
Nick what? Or do you just call him Nick?
I just call him Nick.
And this is the same Nick that you met in June of 2023?
I met Nick, but I don't remember when I met Nick.
Let me show you the same document again, 3602 to 26. Does the top of the document refresh your recollection that you met with Nick?
Yes, I think it's a WebEx source.
And you've been in touch with Nick all the way consistently through June of 2023, correct?
That's incorrect. I not contact him consistently. I think I only met him one time. And I don't hear from him for a very long time. I don't remember when he reached out to me again.
Well, do you remember meeting with him again in early February of 2024?
So you talk about after I met with Nick in June, about 8 months later we met again?
Yes, I'm asking you if you remember having Nick as a point person for you from June of 2023 to today. You may not have talked to him every day, but you've known him for the whole time period, correct?
The court said, "There's so many questions in there. First you ask if he was the point person. Why don't you answer that question?"
Yes, he's the point person.
You were in contact with him since June of 2023, correct?
Yes.
You had an interview with him and with the prosecutors on February 4th of this year, correct?
I don't remember.
February 27th of this year, correct?
I don't remember.
April 23rd of this year, correct?
I don't remember.
May 6th of this year, correct?
I don't remember.
May 13th of this year, correct?
I don't remember.
June 3rd of this year?
I don't remember.
June 23rd of this year?
Yes.
How about yesterday?
Yesterday, you mean, do I meet with them?
Yes.
Briefly right before the court time, yeah, MMHM.
But you met with Mr. Finkel and he showed you documents yesterday, right?
I said I met him briefly.
And during that brief meeting, he showed you documents, correct?
Yes.
And you reviewed the documents with him, right?
I did not review the document. He showed me the document. That's it.
And then he asked you questions about the document, right? He didn't just show you and that's it. He actually asked you questions?
Yes, I think we only met for 10 minutes or so. So, yes, it's a few questions.
So he asked you about 2 documents that he showed you, right?
I don't remember how many documents.
And then he asked you questions and you answered them, correct?
Yes.
He took notes, right?
I don't think so.
And you met him right in this building, right?
Yesterday morning, yes.
And in all of these meetings that you met with him, you never once told him about Ivy, correct?
That's incorrect. He never asked me about the nickname I use at the Discord.
You also never told him that you were active on Discord, correct?
He didn't ask me if I am active. He didn't ask me about the Discord. He didn't even ask me that.
So he didn't ask you and you didn't tell him, correct?
Mr. Finkel said, asked and answered.
The court said, sustained.
You didn't voluntarily tell him about Discord, correct?
The court said, sustained.
Ms. Shrofa said, that's a different question, Your Honor.
The court said, sustained.
How long did you stay on Discord after you started talking to the government?
Mr. Finkel said, relevance objection.
The court said, you may answer.
I don't remember.
You don't remember being active in Discord even until today?
I don't know if I'm still on Discord because I don't, Discord. I don't know. I don't know. Seriously, I don't know.
How many farms do you visit as a visitor on Discord?
I don't know.
10?
I don't know.
15?
I don't know. I answered. I have answered, I don't know.
The court said, sustained.
You were a visitor on Discord at the Himalaya New York Rock Farm, correct?
I don't remember.
How about the Nuremberg Justice Farm? Do you remember being a visitor on that farm this year?
The court said, overruled. You may answer.
This year, I don't think so.
How about last year?
Last year, I don't remember. I don't think so.
How about the Himalaya Melbourne Afinasik farm?
Do you mean last year?
All the way till today, you're still a visitor on that farm, correct?
I don't know.
How about the Himalaya New Zealand farm?
I don't know.
How about the Himalaya 77 Engineer farm?
I don't know.
How about the Rule of Law Foundation?
I don't know.
How about the Rule of Law Society?
I don't know.
Ms. Chen, is it fair to say that if Mr. Finkel did not ask you a question about a specific topic, you did not bring it up?
So.
Just yes or no would be great.
Can you repeat that question?
The court said, I'll allow the answer.
What's the question again?
You testified moments ago that Mr. Finkel did not ask you about Discord, and therefore you did not discuss that topic, correct?
Yes.
Were there other topics that he simply didn't ask you about that you did not volunteer about pertaining to this case?
The court said, sustained.
Did you tell him about the role your husband played in all of these interactions?
I don't remember.
And your husband has never spoken to Mr. Finkel, correct?
That's correct.
Ms. Schrofa said, I have nothing further, Your Honor.
The court said, redirect.
Redirect examination. By Mr. Finkel.
Ms. Chen, approximately how many meetings have you had with me?
I guess 6 or 8, between 6 or 8.
And were those meetings, how many of those meetings were online or in person?
I think we have 2 in person and the rest are online.
And during those meetings, did we talk about Harry Potter?
No.
Did we talk about the New York Jets?
No.
What is the general topic of information that we discuss?
Mr. Finkel asks a question and I provide answer.
And what were the general topics of information I ask you questions about?
Related to the investments.
Ms. Schroff asked you some questions about trading you may have done on the Himalaya exchange. You recall those questions?
Yes.
Have you been able to withdraw any real money from the Himalaya exchange?
Ms. Schrofa said, objection to what is real money.
The court said, if you'll define what you consider to be real money.
Have you been able to withdraw any United States money, United States dollars from the Himalaya exchange?
Ms. Schrofa said, since from what time period?
Ever?
No.
What about pounds, British pounds? Have you been able to withdraw any British pounds?
No.
What about Swiss francs?
No.
Have you ever been able to withdraw any fiat currency from the Himalaya exchange?
No.
So those trades you haven't profited any real money from, correct?
That's correct.
If we can pull up VK5 at page 10. Ms. Chen. Do you remember being asked questions by Ms. Schroff on cross-examination about this page?
Yes.
Do you see where it says use of proceeds?
Yes.
Does it say under use of proceeds invest $100 million into Heyman Capital?
Ms. Schrofa said, Your Honor, I have an objection. I think the government knows the document speaks for itself.
The court said, overruled. You may answer.
No, I don't see it.
After reviewing this document, reviewing Miles Guo videos online.
Ms. Schrofa said, objection to the leading.
The court said, I haven't heard a question yet.
After considering the information in this document and Miles Guo's videos online, what was your understanding of what your investment in GTV would be used for?
Would be used according to the description of the usage of the proceeds in this chart.
If you had known that the money you had sent to Miles Guo to Soraka would be used to invest $100 million in a hedge fund in the name of his son, would you have sent your approximately $200,000 investment?
No. Ms. Schrofa said, objection. It's beyond the scope and it's been asked and answered.
The court said, overruled.
No.
If we can go back to page 2, I think, Ms. Loftus. Sorry, page 1, page 3. You see that information below it says contact details?
Yes.
And there's a WhatsApp text number at the bottom.
Yes.
And then, there's an address 162 East 164th Street?
Yes.
Have you ever been there to the offices that are indicated on this document?
No.
We can take that down. If we can display for the witness what's been marked for identification as VB36. Do you recognize this, Ms. Chen?
Yes.
What is it?
This is the WhatsApp chat I spoke to earlier that Miles Guo sent the GTV investment information, including wire instruction to my husband.
Mr. Finkel said, government offers VB36.
Ms. Schrofa said, no objection.
The court said, okay, it is admitted.
Government's Exhibit VB36 received in evidence. By Mr. Finkel.
Can we publish that, please? Ms. Chen, is this a WhatsApp chat?
Yes.
And is it this chat that you and your husband used to communicate with Miles Guo about the GTV investment?
Yes.
And what language did you communicate with Miles Guo in?
In Mandarin.
You can take that down. Do you remember being asked some questions by Ms. Schroff about the coefficient that you had to multiply your prior investments in to make a determination as to how much H-coin you were entitled to through the MOS farm? Do you remember questioning about that?
Yes.
What is your understanding, if anything? Sitting here today, why trying to calculate the amount of H-coin you were owed was so complicated?
It's on purpose.
Why do you believe that sitting here today?
So that you can never calculate the H-coin each person is entitled to correctly.
At the time that you were filling out that form, Ms. Chen, what was your understanding of what the coefficient even was?
I have no idea what it is.
If we could put up VB16, which is in evidence. Do you remember being asked questions about this document by Ms. Schroff?
Yes.
Can you read the second paragraph, please, that begins, I purchased?
I purchased the G Club membership because it was marked as an investment with stock and shares. However, I never received any stock or shares, nor did I receive any membership benefits. Therefore, I think this is an investment fraud. I am sending this cancellation notice to request a refund.
Did you get a refund, Ms. Chen?
No.
Do you still think that it was an investment fraud?
Yes.
We can take that down. Ms. Chen. You were asked some questions about chats you had with Octopus and someone else on Discord. Is that correct? Do you remember being asked those questions?
Yes.
And those chats were in 2021. Is that correct?
Yes.
And Ms. Schroff was asking you questions about specific words used in a chat from December 2021. Is that right?
Yes.
And sitting here today, do you remember the specific words you used in a chat from 2.5 years ago?
No.
If we can put up what's in evidence as VB31. Do you remember being asked questions about the timing of your investments and your investments in Miles Guo investment project?
Yes.
Do you recognize this document, Ms. Chen?
Yes.
Who created this document?
I create this document.
What is reflected on this document?
This reflects all the money I give to this fraud.
And so column 1 reflects the various entities or projects that you sent money to. Is that correct?
Yes.
And what does column 2 reflect?
Reflect the payment amount I send each of the fraud program.
Ms. Chen, sitting here today and reflecting on the money you sent to these various investment projects. How do you feel about your decision, the decision you made back then to invest?
I feel very regretted. I blame myself that why was I so stupid to be brainwashed and trusted a fraudster and send all the money to all the different entities. That's all part of a fraud scheme.
Ms. Chen, sitting here today, are you also angry about the money you lost?
It's hard feeling. It's extremely painful, and I don't know how to describe the feeling. It's hurting a lot.
Ms. Chen, you said just a moment ago that you felt like you were brainwashed. What are the things that happened to you that you think caused you to be brainwashed by Miles Guo?
Ms. Schroff said, objection to the form.
The court said, overruled. You may answer.
I think it is a messaging. Keeping repeating and emphasizing in your mind that make you believe it is true and make you believe it is true without any doubt. I don't know how it happened, but unfortunately it happened to me. That messaging is repeating. It's emphasizing. It's instilling in my mind, make me trusted every single thing and make me acting as an idiot back then.
Ms. Chen, when you were a follower of Miles Guo? Approximately how many videos or broadcasts or articles about Miles Guo did you watch?
I don't remember.
Approximately?
Approximately hundreds.
And your husband and you watched videos too?
Yes.
And your husband discussed Miles Guo?
Yes.
And discussed these investments?
Yes.
And the two of you made a decision together to invest in these investments?
Yes.
Would you make the same decision today?
Would I make the same decision today?
Sitting here today, knowing what you know, would you make the same decision today to invest in these?
Absolutely not.
Why not?
Because this is fraud. Everything, every program that Miles Guo designed, created and promoted, including all the entities here, are a fraud.
Mr. Finkel said, I have nothing further. Thank you, Ms. Chen.
The court said recross.
Cross-examination. By Ms. Schrofa.
Ms. Chen, what is Getter?
Mr. Finkel said, objection scope.
Ms. Schrofa said, she said all of this is a big fraud.
The court said, I'll allow the question. Go ahead.
What is Getter?
She made a statement of something I did not say. I said all the programs.
Ms. Schrofa said, Your Honor, it's a question for the witness. Getter.
The court said, you can answer the question. What is?
My understanding, it's a social media platform.
And it is a social media platform today, correct?
Mr. Finkel said, scope.
The court said, overruled. You may answer.
Mr. Finkel said, also there's like a feedback. I don't know whose microphone that is.
I guess so.
How about G-Fashion? What is G-Fashion?
The court said, sustained.
Ms. Schrofa said, she said everything was a fraud.
I didn't say that. I say all the money I sent to those. That's what I'm saying, I did not say that.
The court said, sustained.
G-Fashion was an access that you had through G-Club, correct?
The court said, sustained.
Let's see VB 36. You were shown this video, correct, Ms. Chen?
Yes.
And Mr. Finkel asked you in what language you spoke to Mr. Guo, correct?
Yes.
Mr. Guo speaks terrible English, correct?
I don't know.
You never had a conversation with Mr. Guo, correct?
Mr. Finkel said, objection.
The court said, the question is whether or not she's had a conversation with Mr. Guo. You may answer.
When you say conversation, are you saying have I talked to him?
That's a conversation, to talk to someone.
I've been in meetings with him.
My question is, have you ever had a conversation with Mr. Guo?
No. The answer is no.
You were asked questions about the coefficient, correct? You can take that down. Jorge. Thank you. And you told Mr. Finkel and this jury that you thought the formula used was on purposely complicated so that nobody can ever calculate their amount. That's what you said, right?
That's not what I said.
Well, you tell me what you said.
I said the H-coin allotment calculation is based on the investment. And there's a coefficient goes with the investment. There are so many different investment projects out there. Some of them are still not being part of the fair fund distribution or some other reasons that there's no way to calculate the true benefits of all the confirmed investment in order to calculate the confirmed H-coin allocation.
Didn't you say on direct that you thought it was purposely complicated so that nobody can ever calculate it? Isn't that what you just said?
As I said, yes, that's what I said.
Okay, so let's try this way. You know that there were audit committees at the farms, right?
Mr. Finkel said, scope objection.
Ms. Schrofa said, it is part of the coefficient question that Mr. Finkel pushed.
The court said, go ahead.
There were audits conducted, correct?
Yes.
There were audit committees, correct?
I don't know what you mean by audit committees. I know there are audits.
Weren't you part of the audit committee?
No.
You did not check and do audits on whether or not the H-coin was properly allocated.
Mr. Finkel said, asked and answered.
The court said, sustained.
Ru Shui was part of the audit committee, correct?
Mr. Finkel said, scope.
I don't know if Ru Shui is part of audit, and then I explain my role. My role is to verify if the H-coin for the MOS farm members were calculated correctly. And based on my volunteer experience, I think the design of calculating H-coin quota is so complicated in the design that complicated for purposes so that it can never get H-coin calculated or confirmed correctly.
But you calculated it, correct, while you were doing this evaluation.
I say I re-verify it, but
To re-verify something, you have to undertake a calculation, correct?
right.
And you did it as a volunteer, correct?
Mr. Finkel said, Your Honor, ask Ms. Schroff to allow the witness to answer the question. And to just pose a question, and just let her answer instead of just.
The court said, go ahead and answer.
You did it as a volunteer, correct, yes or no?
What's your question?
You verified as a volunteer, correct? You undertook verification process as a volunteer, correct?
That's incorrect, because I verified H-coin. But an H-coin verification is never ending because there are monies still out there have not been sent back to Miles Guo. So therefore, even though I verify the coin to the extent, by the time I no longer volunteer, that coin is not the final coin each person is entitled to.
That wasn't my question, but okay. My question to you was, you were part of the verification process, correct? It's a simple question.
Mr. Finkel said, asked and answered.
The court said, sustained.
Ru Shui was part of that process, correct?
The court said, sustained.
Fei Fei was part of that process, correct?
Mr. Finkel said, scope.
Ms. Schrofa said, same scope that you opened the door to. Fei Fei was part of that process, correct?
Mr. Finkel said, I don't think I opened that door.
The court said, not to this.
Little Sarah was part of that process, correct?
The court said, sustained.
When Mr. Finkel asked you what coefficient was used, you said, and I quote, "You have no idea." That was your question on redirect, right? That was your response. You remember that?
Mr. Finkel said, mischaracterizes.
Ms. Schrofa said, I don't think so.
The court said, I'll let you answer. Go ahead.
You said you had no idea, correct?
I have no idea why design like that. I think it's overly complicated.
You never told anybody that the whole time that you volunteered for them, right? Never once did you say, this is too complicated, redesign it, correct?
Mr. Finkel said, relevance.
The court said, sustained.
Did you ever express what you said to the jury now to anyone at the Mountain of Spice Farm?
The court said, sustained.
Let me show you VB 16. You see this, Mr. Finkel asked you questions about this document?
Yes.
And the left-hand side is your and your husband's joint email address, correct?
Yes.
And on the side over there gives you the date of May 14th, correct?
Yes.
2023, right?
Yes.
And you wrote this email, correct?
We wrote this email.
Right. And you wrote it because you wanted your money back, correct?
We wrote the email to get my money, to ask for refund.
And if you had written, I purchased G Club membership and I have simply changed my mind, you would never get your money back, right?
Mr. Finkel said, calls for speculation irrelevant.
The court said, sustained.
You drafted this because you thought this is the best shot at you getting your money back, right?
I drafted this because I want my money back.
Exactly. And you thought this language would help you get your money back?
Mr. Finkel said, objection.
The court said, you may answer.
I put this language because that's what I believe is true. I purchased GTV shares and the G Club membership was given as free, so I am just telling the truth here. It was promoted as GTV share investment. I have gained nothing. So I need my money back because my money was into the so-called G Club account.
No, it was sent to G Club membership account, correct?
Mr. Finkel said, that's argumentative.
The court said, sustained.
Where does it say in this email that G Club was going to be free?
What's your question?
Where in this email do you see that G Club was meant to be free? Let's scroll down for you. You see the word free anywhere in here? I'll move on. Let's go to the next document.
Mr. Finkel said, I object. It mischaracterizes testimony.
Ms. Schrofa said, the document speaks for itself. The email is dated May 2023?
Mr. Finkel said, asked and answered.
The court said, sustained.
When was Mr. Guo arrested?
March 2023.
And you sent this after his arrest, correct?
Mr. Finkel said, objection, court's ruling.
The court said, overruled.
You sent it after his arrest, right?
Yes.
Let's go to GXVB 31. You talked about the summary chart, right?
Yes.
Mr. Finkel went over this with you?
This is the chart I put together. No one went over with me.
You never discussed this chart with him when you met him in his office?
There's no need to discuss the chart. It's just an outline of the payment.
I didn't ask you if it was discussed.
I didn't discuss.
And you sent this document to him, correct?
Yes.
And you sent it to your friend Nick at the FBI, correct?
Mr. Finkel said, objection.
You sent it to the FBI agent?
The court said, sustained. There's no evidence that they're friends.
Do you consider him a friend? Do you consider him your friend?
No, he's not someone I know.
But you don't consider him a friend?
Mr. Finkel said, asked and answered.
The court said, sustained.
Let's look at this document you created. You created this, right?
Yes.
And you put all of this information, right?
Yes.
And who did you first send this document to?
This document I think first I sent, I don't remember who I sent this document to. I think I sent it to Nick, yes, MMHM.
And you were also asked by Mr. Finkel, were you ever able to get your H-coin investment money back or redeem it for pounds or yen? You remember that question?
Yes.
The first time you ever tried to do that was in May of 2023, correct?
Mr. Finkel said, objection to relevance.
The court said, you may answer.
You mean the redemption?
Yep.
Yes.
After Mr. Guo's arrest, correct?
Yes.
After his indictment, correct?
After I realize it's a fraud, because I read indictment document. He's using my money to pay for his luxury item.
After you read it in the indictment, correct?
Yes.
And an indictment is nothing but a piece of paper accusing someone, right?
Mr. Finkel said, objection.
The court said, sustained. Don't ask her for legal conclusions.
Ms. Schrofa said, I'm asking for her understanding, Your Honor.
Mr. Finkel said, it was sustained is my understanding.
The court said, sustained.
Ms. Schrofa said, I have nothing further.
Mr. Finkel said, nothing further. Thank you, Ms. Chen.
The court said, thank you. You may step out of the courtroom.
Witness excused.
The court said, would you approach, please?
Continued on next page. At the sidebar.
The court said, any further witnesses?
Mr. Finkel said, yes.
The court said, I just want to remind you that you need to address the Hyena matter before the close of your case.
Mr. Finkel said, should we do that now?
The court said, you can do it now, yes.
Mr. Horton said, I just wanted to put the option of doing it after the jury is excused so we don't take up the jury's time.
The court said, okay, that's fine.
Continued on next page. In open court.
The court said, the government may call its next witness.
Mr. Ferguson said, the government calls Jessica Volchko.
Witness sworn.
The court said, please state your name and spell it.
The witness said, Jessica Volchko. Jessica Volchko.
The court said, please speak into the microphone so that you can be heard. And when the mics are tilted up towards the ceiling, that is when we get the feedback, so please don't do that. Go ahead. You may inquire.
Mr. Ferguson said, thank you, Your Honor.
Jessica Volchko, called as a witness by the government, having been duly sworn, testified as follows. Direct examination. By Mr. Ferguson.
Good afternoon, Ms. Volchko.
Good afternoon.
Where do you work?
I work for the Federal Bureau of Investigation, which is also known as the FBI.
What part of the FBI do you work for?
I work for the Computer Analysis Response Team, which is also known as CART.
And what is CART?
CART is responsible for the collection, preservation, and analysis of digital evidence.
And what's your position within CART?
Digital Forensic Examiner.
What are some of your duties or responsibilities as a digital forensic examiner in CART?
To receive digital evidence, items such as hard drives, cell phones, laptops, and extract data from those devices and then process and analyze the data.
When you say extract data from the devices, what do you mean by that?
I mean we can collect all of the user-generated files, or all the files from a piece of digital evidence and then process that copy. It's an exact copy of the original item.
What's a 1B number?
That is a number that's assigned to an evidence item. So each evidence item for a case has a unique 1B number.
And what are some examples of evidence items you commonly deal with in CART?
Some of the digital evidence items could be a cell phone, a laptop, a hard drive, an SD card.
And Ms. Volchko, if you tilt the mic towards your mouth, or point it towards your mouth, maybe it will help with the feedback. Now, Ms. Volchko, aside from testimony, what involvement, if any, did you have in this case?
Just an administrative role. Communicating with the case agents about the items that they requested to be examined and then certain timelines. Deadlines that we needed to produce results.
What, if anything, did you do on March 15, 2023?
I assisted with the collection of digital evidence at a search warrant in Mawa,
What state is that in?
New Jersey.
Ms. Volchko, do you recall? Or even just a ballpark recollection of approximately how many devices were seized in this case?
I would say a couple hundred, maybe.
Mr. Ferguson said, okay. Your Honor, at this time, sorry for the feedback. At this time we'll offer a stipulation between the parties. It is Government Exhibit Stip 17. And Ms. Loftus, I assume no objection.
Mr. Kamaraju said, no. That's fine.
Mr. Ferguson said, all right. Is it admitted, Your Honor?
The court said, it is admitted.
Government's Exhibit Stip 17 received in evidence.
Mr. Ferguson said, thank you. If we could publish that, Ms. Loftus. All right. So I'll just read the intro to the stip. It says, it is hereby agreed, in the below chart. The exhibits listed under column A, and if we could scroll down slightly, Ms. Loftus. There we go. In the below chart. The exhibits listed under column A are electronic devices and/or true and correct photographs of electronic devices. Column B lists a description of each electronic device identified in column A. Column C lists the location from which each electronic device listed under column A was recovered or obtained. And then the below chart. The exhibits listed under column D are true and accurate copies of data extracted from the electronic devices described in column B. And I think, Your Honor, just for reference, I don't need to pull it up and read it right now, there's another stipulation between the parties that's in evidence. It's GX Stip 21 that relates to some of the exhibits I'm also about to offer, and it has translations. So pursuant to those stipulations, the government is going to offer the following exhibits: Government Exhibits 1B15D, G, and GT, and 9, 1B16C, 1B18A, 1, 2, 1B69B and BT, B1 through B18, and their corresponding Ts, 1B70A and A1, 1B71A1 to A6, and 1B71E, F, G, H, and 9, 1B89, 1B89J, and J1 and J2, 1B91C38, 1B91B26, minus 27, minus 31 through minus 33, 1B92B13, 1B121, 1B121AM, 1B124, 1B124A, C, E, F, G, H, M, and R, 1B125, 1B125A, and 1B125F through 1B125S, 1B185M, 1B204-13, minus 47, minus 48, 1B227A, B, and F, 1B255C and D, and finally, 1B272B. That's all.
Mr. Kamraju said, no objection pursuant to the party's stip, Your Honor.
The court said, it is admitted.
Government's Exhibits 1B 15D, G, GT, I, 1B 16C, 1B 18A, A1, A2, 1B 69B and BT, B1 through B18, and their corresponding TS, 1B 70A and A1, 1B 71A 1 to A6, and 1B 71E, F, G, H, and I, 1B 89, 1B 89J, and J1 and J2, 1B 91C 38, 1B 91B 26, minus 27, minus 31 through minus 33, 1B 92B 13 received in evidence. Government's Exhibits 1B 121, 1B 121 AM, 1B 124, 1B 124A, C, E, F, G, H, M, and R, 1B 125, 1B 125A, and 1B 125F through 1B 125S, 1B 185M, 1B 204-13, minus 47, minus 48, 1B 227A, B, and F, 1B 255C and D, and 1B 272B received in evidence.
Mr. Ferguson said, all right. Actually, Ms. Loftus, if we could go back to Stip 17 just to start. And Your Honor, may I approach to give a copy of the stips to the witness?
The court said you may.
Mr. Ferguson said, thank you. Okay. Ms. Loftus, if we could go to thank you, page 4. And if we could zoom on row 4.
By Mr. Ferguson.
All right. Now, Ms. Volchko, looking at this stipulation, what type of device was 1B71?
A white iPhone XR.
And it references an IMEI. Just briefly, could you explain what IMEI is?
An IMEI is kind of similar to a serial number. It's a unique number assigned to a cell phone.
And where was this white iPhone recovered?
It was recovered from Wong apartment inside a bag in closet.
Mr. Ferguson said, all right. And let's go to Ms. Loftus, if we could, show on the left side 1B71I. And if we could put on the right GXGC276, at page 2. And Ms. Loftus, if you could zoom on the center email from Max K. Can you just put that on the right? Ms. Volchko, looking on the left, what color is that car?
It's red.
Do you know the model?
I'm not sure.
Do those doors open horizontally or vertically?
Looks like up and down, vertically.
And Ms. Volchko, looking at the stipulation that you have, on the left. Is this one of the exhibits from 1B71, the phone from Wong apartment?
Yes, according to the stipulation.
Mr. Ferguson said, all right. And if we could look at now on the left. If we could actually pull up Stip 17 again on the left, please. And if we could go to page 4 and zoom on row 5. All right. And now what device is 1B89?
1B89 was a red iPhone 11.
And who was that recovered from?
The location was Alex H., pursuant to a search warrant executed on March 15, 2023.
Mr. Ferguson said, and if we could now replace on the left government exhibit 1B89J2. Okay. And Ms. Volchko. Is this an audio recording from the phone recovered from Alex H. we just looked at?
Yes, according to the stipulation.
Mr. Ferguson said, and can we play the recording, please?
Audio played.
All right. Ms. Volchko, I want to go back to 1B71. We don't need to pull it up. But if you can, could you just remind us where the phone 1B71 was recovered from?
1B71 was recovered from Wong apartment inside a bag in closet.
Mr. Ferguson said, okay. Ms. Loftus, let's publish 4 exhibits. It's 1B71E, F, G, and H. Ms. Volchko, just focusing on the top right, can you read what it says on that flyer there?
GTV investors protest SEC's collaboration with CCP.
Mr. Ferguson said, all right. We can take that down. And Ms. Loftus, if we could just pull up step 17 quickly. Could we go to page 2? And the third row from the bottom, if we could zoom on that. Ms. Volchko, what type of device was 1B124?
A white iPhone.
And where was that white iPhone recovered?
Sherry apartment, inside a bag.
And the exhibits to the right of that, those are items that were taken or extracted from that cell phone. Correct?
That's correct.
Mr. Ferguson said, all right. Let's go to Ms. Loftus, Government Exhibit 1B124. Let me ask you first, Ms. Volchko, what type of report is this?
This is a preliminary device report of an iPhone.
And what sort of information is on a preliminary device report?
The identifiers that are associated with the device. It would be a model number, a serial number, a phone number.
Mr. Ferguson said, and if we could go to page 2. Ms. Volchko, directing your attention to where it says user accounts. What type of information is in that section of a report like this?
Those are user accounts that are extracted from the cell phone. So it could be from different applications that are on the cell phone that a user logged into.
Mr. Ferguson said, and could we zoom on row 10, Ms. Loftus? Can you read what's in row 10, please?
Row 10 is a user account associated with Chrome. There's an email, gumiles@gua.media.
And then what's the website address to the right of that?
https://gtv.org.
Mr. Ferguson said, and if we could scroll down slightly, just to row 16. All right. Can you read what's in row 16, please?
Row 16 is a user account associated with Chrome, with an email wengiguo@gmail.com.
Mr. Ferguson said, and if we could go to row 21. Just scroll down. Ms. Volchko, just focusing you on the right-hand side of these rows, do you see how it says guitar.com?
Yes.
And then what does it say to the left of that?
Miles.
And then focusing you on row 24 where it says Threema, what's the name to the right?
Miles Guo.
Do you know what Threema is?
It's a messaging application.
Mr. Ferguson said, if we could scroll down. And 29, where it says WhatsApp Business, what's the name?
Miles Guo.
Mr. Ferguson said, and if we could zoom out and go back to page 1. And if we could zoom on device name. May I just have a moment, Your Honor?
The court said yes.
Mr. Ferguson said, Ms. Loftus, you could zoom on the, that's great.
By Mr. Ferguson.
And focusing on where it says device name, what's the device name?
Boss, with a 2 in parentheses.
All right. Now let's go to some of the contents of this phone. Let's go to 1B124A. Ms. Volchko. Can you read what it says on the sign in the center?
SEC and DOJ are killers.
Let's go to 1B124G. Can you read in the bottom left, in the sign being held there? Can you read the name listed there?
Paul Hastings.
Let's go to 1B124F. Ms. Volchko, can you read the text in the top left?
Isabel Despins and Daniel Copeland wedding October 15, 2022.
And this photograph was on the boss phone, the one we were just looking at, right?
Mr. Kamraju said, asked and answered, Your Honor.
The court said, sustained.
Ms. Volchko, do you know who Isabel Despins is?
I do not.
Do you know who Daniel Copeland is?
I do not.
Mr. Ferguson said, Ms. Loftus, can we zoom on the, the right half of this photograph? Ms. Volchko, the man wearing the white shirt in the middle, do you know who he is?
I do not.
On the left, the young woman circled in red, do you know who she is?
I do not.
On the right, the 2 young women circled in red, do you know who they are?
I do not.
Do you know who circled them in red in this wedding photograph?
I do not.
Mr. Ferguson said, Ms. Loftus, if we could pull up on the left the same photograph, 1B124F, and then on the right, 1B124R. And if you could zoom, Ms. Loftus, on the picture on the right, the one we were just looking at, on the man's face. The one in the white shirt.
By Mr. Ferguson.
Ms. Volchko, directing your attention to the left, can you read what it says in the top center? On the left.
On the left.
Yes, please.
Dear all victims from Luke Despens, Paul Hastings, and O'Melveny. If they have represented your legal cases and have blackmailed, extorted, or scammed you, NFSC fellow fighters will spend $10 million, minimum, to reward those who can provide us the proof of their criminal activities. Illegal bank accounts. Illegal incomes. Scan the code to contact us.
And then focusing on the left still, there's a picture of a man. Can you read the text underneath that picture?
Luke A. Despens, partner of Paul Hastings.
Do you recognize the image on his forehead?
I do not.
And Ms. Volchko, directing your attention back to the stipulation you have. What device did 1B124 come from?
A white iPhone seized from Sherry apartment inside a bag.
Mr. Ferguson said, let's go back to stip 17, please. Let's go to page 3, please. And if we can zoom on the third row from the bottom. And just focusing you on where it says GX4, what type of device was 1B15?
A white iPhone 12.
And where was that white iPhone recovered from?
Wong apartment, bedside table.
Mr. Ferguson said, and Ms. Loftus, if we could now publish 1B15 GT, the translation. Now while this is coming up, what are notes on an iPhone?
Notes is an application where a user can write memos or save text.
Mr. Ferguson said, thank you, Ms. Loftus. Maybe we can make it perfect. Okay. And what type of information was extracted from 1B15G?
A note content from a note from the phone.
And could you read in the column D, the translation column? Could you read? I won't make you read all of it, but can you read some of those lines? You can start from the beginning.
The scheduled farm meetings with Mr. Guo in 2023, Eastern Time. Subject to confirmation, are as follows: Myfin Group, Wednesday, January 11th. 5 p.m. Eastern Time, using WebEx. Athena, Friday, January 13th, 7 p.m. Eastern Time. Taiwan Farm, Saturday, January 14th, 9 a.m. ET.
And Ms. Volchko. I'll ask you now, you can just skip down to the bottom of the list and read where it begins. The boss.
The boss just mentioned that no meetings will be scheduled from the 20th to the 25th. Please check if the times in this table conflict with any legal meetings.
And now focusing you to the column to the right of that where it says created time. What's the created time?
Is March 31st, 2024 at 8:44 a.m.
And what dates or times can be populated in that field?
It appears to be the time that this note was tagged from the full phone report.
And what does it mean to tag a note in a phone?
Items that are tagged from a cell phone report can later be used to generate a smaller excerpt version of that report.
And directing you to the top left, what does it say there?
Tags.
Mr. Ferguson said, all right. Let's go back to stip 17. We'll go to page 4. And just on that tagging topic, how commonly are cell phone extractions reviewed?
They're often reviewed.
And so let me focus you, Ms. Volchko, on the third row from the bottom here, with 1B92. Mr. Ferguson said, if you could zoom on that. All right. And what device is 1B92?
An Apple MacBook Pro.
And from whom was that MacBook Pro recovered?
Alex H.
Mr. Ferguson said, and if we could now publish something from the MacBook, 1B92B13. And if we could zoom on the top half. Can you read the name on the top left?
I'm unsure of the pronunciation, but Haoran, last name He.
And just focusing you on the top right. Starting with accomplished, can you just read those 4 lines there?
Accomplished business development manager bringing 5-year track record of success improving sales and growing company customer base through effective program management, strategic planning, and team leadership.
Mr. Ferguson said, and if we could scroll down. If you could scroll. Just underneath experience, Ms. Volchko, can you just read the first 2 lines underneath experience?
March 2014 to current. Director and shareholder several property development firms.
Mr. Ferguson said, and if we could zoom out. And just zooming on the top left. What's the email address listed here?
cool_hhr@hotmail.com.
Are you familiar with Proton Mail?
I'm aware of what it generally.
I'm sorry. What is Proton Mail?
It is an encrypted email. It can be accessed through a web browser or an application.
And what's your understanding of whether, government search warrants can get the contents of a Proton Mail account?
Mr. Kamraju said, objection. Speculation.
Mr. Ferguson said, based on her.
The court said, if you know.
I have never seen a Proton Mail search warrant return.
Mr. Ferguson said, all right. Ms. Loftus, let's just pull up quickly what's in evidence as GXGC 309. And if we can just zoom on the top email quickly. And Ms. Volchko, just looking at the very top line, what's the domain of that email address?
gclubs.com.
And then focusing you still on the header, the very last line of the header, can you read that, under? That ends in .pdf.
yachtcontract.pdf.
Mr. Ferguson said, and let's now go to page 8, please. And if we could just zoom on line 9, please. Do you see at 9, it says, description of the yacht, and then beneath that, there's an entry that says name? Can you read the name?
Liberty.
Mr. Ferguson said, and if we could zoom out. And if we can zoom on just the top line, please, of this contract, yeah. Perfect. Thank you. Do you see in the middle there's a star? Can you read the text to the right of the star?
7-star yacht transport.
Mr. Ferguson said, all right. Now, Ms. Loftus, let's put on the left stip 17 at page 2, please. And then on the right stip 21 at page 2. And I'll ask you, on the right, can you zoom in on paragraph 3, please? And then on the left, can you please zoom in on the second row from the bottom?
By Mr. Ferguson.
Okay. Ms. Volchko, focusing you on 1B125, what type of device was that?
A blue iPhone.
And where was that blue iPhone recovered?
Sherry apartment, inside a bag.
All right. Now focusing you on the stipulation on the right, can you read paragraph 3?
GX1B125F, GX1B125S, and their subparts, GX1B125FI, etc., are true and accurate copies of data extracted from 1B125Z. GX1B125F, GX1B125S contain a column titled Translation, which contains true and accurate translations of foreign language text/audio, video from GX1B125F, GX1B125S, and their subparts.
Mr. Ferguson said, now, Ms. Loftus, let's now publish 1B125F. And while we're waiting, Ms. Volchko, in the email we just looked at, what was the name of the yacht?
I believe it was Liberty.
And what was the name of the shipping company?
I think it was 7-star.
All right. Now, Ms. Volchko, focusing you on this exhibit, what's the date in the top center?
September 17, 2021.
And focusing you on the far left column, what's the date listed there?
September 17, 2021.
And then in the from column, are you able to tell what type of chat this is?
Based on the phone number, it looks like WhatsApp.
And what is the name listed in the from column?
That's the contact name.
Mr. Ferguson said, all right. Now, Ms. Loftus, if we could scroll down slightly. This may only be one. Okay. If we could keep scrolling. All right. Now focusing you on the next text, who is that text, I'm sorry, or chat message? Who is that one from?
I'm sorry. Which one are you referring to?
Just the second column from the left, the first message on this page, who is that message from?
That's the owner of the device.
And what's the name?
Miles Guo.
Mr. Ferguson said, okay. Let's go back up. And Ms. Volchko, if we could read this. I'll read the part of Gladys and you can read the part of Miles Guo.
Okay.
All right. So boss. This is the information about the new boat Max sent to you. The first shipping company is 7 Star. And their price is $90,000, from Genoa, Italy to Boston, it takes 15 days. The ship will arrive at Boston on October 26. If the weather is good, then the ship can travel to Connecticut, which will take about 3 to 4 days. Meaning it will arrive in Connecticut at the end of October. Another shipping company is Peters in May, with a lower price of about $59,000. The ship will travel to Fort Lauderdale, Florida. But it is even farther than Connecticut, and it will take longer to arrive in Connecticut. Also, it doesn't have a fixed delivery date. It may arrive in October or November. Another thing to note. The cost of arranging a ship to travel from Florida to Connecticut is very high. Because it is far away from Connecticut. It will cost about $15-$20,000 and it will take about 5 to 6 days. So if you want low risk, and the ship must arrive by the end of October, we should use the first company, 7 Star. But if the time can be flexible, we may choose the second company, Peters in May. It's cheaper.
Max, I'm very annoyed. I agreed with the end of September. But he scheduled it to the end of October. I'm very annoyed and very annoyed. Okay. Just send it to Seven's house according to this. It's very annoying. It's the fastest one.
And just to pause for a moment, Ms. Volchko, do you see? Mr. Ferguson said, and maybe we can scroll up just so we can see the column headings. All right. At the far right column, what's that column titled?
Attachments.
Mr. Ferguson said, and if we scroll down. Ms. Volchko, when an audio message is sent in an extracted WhatsApp chat, how is the audio message extracted from the phone?
It's extracted as an attachment.
Mr. Ferguson said, and we'll continue with the dialogue in a moment, but Ms. Loftus, if we could play GX1B125F1.
Audio played.
Mr. Ferguson said, all right. Let's go back to the chat. It's 1B125G. Okay. So I'll keep reading Gladys's part. 7 Star gave me a schedule. Our boat can be loaded on the ship in Italy on October 10th and it will arrive at Boston on October 26th. After that, it will travel to Connecticut.
F-word PH, November 10th again, this is really crazy. It's the only way. There's no way out. What should we do?
Mr. Ferguson said, scroll down. Oh, that's the end. If we could pull up quickly, Ms. Loftus. Government Exhibit Pro 466 at page 20. And if you could scroll down slightly. All right. If you could just zoom on that paragraph, please.
By Mr. Ferguson.
All right. Can you please read the second sentence here?
Please allow me to introduce myself again. I am Gladys, the assistant of Mr. Miles Kwok.
Mr. Ferguson said, all right. Ms. Loftus, let's go back to GX1B125, the next one. Let's go to G. All right. And what's the date of this chat excerpt, Ms. Volchko?
September 24, 2021.
And who is this chat between?
This appears to be between Gladys and Miles Guo.
Same as the one we just looked at before?
That's correct.
Okay. So in this one, the first entry has something in images. Do you see that?
I do.
And the attachment column is filled out. When someone sends, a photo message. How is that extracted from a chat report?
It's extracted as an attachment.
Mr. Ferguson said, so Ms. Loftus, if we could just pull up quickly 1B125G1. It's actually, okay. If you have it, Ms. Loftus. Okay. Thank you, Ms. Loftus. So we can go back to the report. And if you want to just zoom on that image we just looked at.
By Mr. Ferguson.
Can you read the text on that?
Liberty.
Mr. Ferguson said, and if we could zoom out. All right. And we can do the dialogue again. If you could read the Miles Guo part and I'll read the Gladys part.
We'll see, don't say it now, let's say it by then. This square and upright font. The same font as Lady Made PH, the square and upright font.
That's the third one?
The three models that are, that E, and that non-standard, please be more standard. Okay.
And are R and E letters in the word liberty, Ms. Volchko?
They are.
Mr. Ferguson said, all right. Let's go to 1B125I. And if we could just zoom on the image. And these are from Gladys. What's the text in these images?
Liberty.
Mr. Ferguson said, you can zoom out. All right. I'll read Gladys. Boss, these are the fonts of the new ship, which one do you like best? The row on the left is 28 centimeters in height and on the right 30 centimeters. Mr. Ferguson said, we can scroll down. And then it says, the one below is just a clearer version.
This one.
Mr. Ferguson said, and then can we zoom on the picture that Miles Guo sends? And do you see one of these is circled in blue?
I do.
Mr. Ferguson said, we can zoom out. And then the question, so you like the fourth 28 centimeters high, right? Mr. Ferguson said, all right. We can take that down. And let's go to step 17, at page 4, please. We're going to look at the bottom row. All right. What type of device is 1B272?
A black iPhone 13.
And where was that recovered?
Max Krasner's person, pursuant to a search warrant executed on March 15, 2023.
And if we can go to 1B272B. While we're waiting, Ms. Volchko, in March 2020, what state were you living in?
New Jersey.
And around that time how difficult, if at all, was it to obtain N95 masks?
Mr. Kamraju said, objection. I'm not sure what the relevance is.
The court said, I'll allow the question.
I recall it being fairly difficult.
If we could, it's still coming up. Mr. Ferguson said, okay. Thank you, Ms. Loftus. Ms. Volchko, what type of images are these from 1B272?
These appear to be screen captures.
And can you remind us, who was 1B272 recovered from?
Max Krasner.
Okay. And focusing on the image, what does it say at the very top, next to the, well? Just at the top, underneath the time?
Mileson.
Do you know who Mileson is?
I do not.
All right. So I'll read the white and you can read the green. Let's do some from Hudson to Lamp and Lamp to me before end of the week. Amount 10 millimeters.
So this will be a loan from Hudson, New York to Lamp.
What is the source for Hudson?
Loan from ACA.
Can we do another loan to Lamp?
From Hudson.
Yes.
Hi Mileson, GSNY.
We can stop there. Do you know what Hudson is?
I do not.
Do you know what Lamp is?
I do not.
Do you know what ACA is?
I do not.
If we can go to page 2. All right. Is this another screen capture, Ms. Volchko, from the same phone?
Yes.
All right. If you could read the first two, the green messages, please.
Hi Mileson, the 3M has been processed. We should be able to do the 7M tomorrow. Can you confirm the address on your account, as it doesn't say in the wiring instructions?
And we can go to page 3. And can you read the green text here?
Promissory note from Lamp to Hudson Diamond V5 1921. Docs.
And the next?
Promissory note from Mileson to Infinity V5 1921. Docs.
And can you read the last screen text there?
I will be processing the gift from Lamp to May for 500,000 now.
Mr. Ferguson said, let's go to page 4. And we can keep scrolling, actually. You can keep going. Let's scroll to page 6. Please. And can you read the first 3 green texts?
Sure, I will check. Hudson, New York has about 13M in IDB, and about 5M in Morgan Stanley. Lamp's signature has 7.3M at the moment.
Let's skip down to page 15. All right. And I'll read the white. The white says, Hi Max. Let's do the 10 from Lamp.
Hi Mileson, does it have to be all in one shot?
Nope. How much are you thinking?
Where do you prefer IDB or signature?
Only signature. Let's go to page 18. So I had said, only signature, and then it says. They insist, so we need to do 20 before signature has problem. Hatham knows.
Okay, currently we have 7 in signature, so maybe 5 first. We need to send funds back to signature from IDB, which has 5.
Do you know who Hatham is, Ms. Volchko?
I do not.
All right. Let's go now to page 20. All right. Now what name is listed underneath the time on this image capture?
William J.E.
And can you read the first 3 texts?
Hi William, attached is a new account for Hudson. Hudson Diamond NYLLC International Wire Instructions. PDF.
And then the white says, okay. Please prepare the loan agreement ASAP. Thanks, hi. Let's go now to page 21. All right. Now what's the name underneath the date in this screen capture from Max's phone?
Yvette W. July 15, 20.
All right. And I'll read the white. We can just read the first 2. Hi Max. Any updates about the new 15 of IDB?
Hi Yvette, I had shared the info with W, and he said he is working on it. I can follow up with him.
Mr. Ferguson said, all right. Let's go to 22. Just go to the next page. One more. All right. And now the name underneath the time here?
Mileson.
All right. And I'll read the white, you can read the green. Go. Hi Max. You have the 20mm director's draw ready too.
Hi Mileson, I think some is ready but not 20M. The company doesn't have that much, we will need funding first.
I believe you have 10?
There is 5M in Carney Bank now, and about 7M in signature.
Okay, 7 will be sent out end of the week, please prepare. I will fund more after.
Signature is the operating account. Hatham says it should go from Carney. We'll prepare to do a transfer, Carney.
Mr. Ferguson said, all right. Let's go back to step 17 at page 3, please. Actually, maybe we can just use the paper. Ms. Volchko, just focusing you on 1B18 on page 3, towards the middle of the page, you got it?
Yes.
What kind of device is that?
It's a mint green iPhone.
And where was it recovered from?
188 East 64th Street, apartment 1601, New York, New York.
And how is that defined?
The Wong apartment, kitchen counter.
Mr. Ferguson said, all right. Ms. Loftus, on the left side can we pull up 1B18A1 and on the right 1B18A2? And those are from the Wang apartment phone, or the one we were just talking about, 1BA2. We may need just a moment. Your Honor. Your Honor, unfortunately, Ms. Loftus's computer crashed, so it may be a few minutes. If the court wanted to address the matter we had discussed briefly at sidebar, we could do that now and take a break?
The court said, all righty. Members of the jury will take a very brief pause of a few minutes, and I'll call you back. Remember, you're not allowed to discuss this case amongst yourselves. Don't permit anyone to discuss it in your presence. Don't listen, watch, or read anything having to do with this matter.
Continued on next page. Jury not present.
The court said, you may step out. Don't discuss your testimony.
Witness not present.
The court said, you may be seated. Is it Mr. Horton who will be addressing this matter?
Mr. Horton said, yes. Thank you, Your Honor.
The court said, go ahead.
Mr. Horton said, the government makes a formal application pursuant to Hay for the admission of co-conspirator statements and agent statements that have been elicited through the trial. Your Honor has heard now 6 weeks of evidence about the RICO and fraud conspiracies in this case, and how the defendant Miles Guo operated the conspiracy, both through his own words.
The court said, if you'll get a little closer to the mic, please.
Mr. Horton said, evidence about how the defendant, Miles Guo, operated his conspiracy both through his own words on broadcasts that are in evidence and by directing of agents to act. And that includes co-conspirators and others who took direction from Miles Guo and his co-conspirators. Many of these statements were not offered by the government for their truth but because they were false. They were lies, and so they're not hearsay for that reason. Others of these statements were offered for additional non-hearsay purposes. They were commands to other agents. They were offered for their effect on witness listeners, for example. To the extent that the government has offered Guo's and his agents' statements for their truth. The court has much more evidence than it needs to make its Hay finding. Again, the standard for that is preponderance, just that it's more likely than not that a conspiracy existed. That Miles Guo and these declarants, who I'll walk through in a moment, were all members of that conspiracy together, and the declarants were speaking in furtherance of that conspiracy when the statements that the government elicited were made. And of course, in making that determination, the court ought to consider the hearsay statements themselves as evidence for the Hay finding. So I'll start with, I grouped them for the court. Start with the group of the sort of core co-conspirators.
The interpreter said, Your Honor, the interpreter would ask the counsel to slow down. I was not able to catch up.
Mr. Horton said, I can slow down. Co-conspirators who are repeat players who participated in and spoke in furtherance of the conspiracy. So the court addressed Yvette Wang early in trial, in view of her guilty plea to the conspiracy with Miles Guo. Of course, there was extensive additional statements of Ms. Wang elicited throughout the trial, including that she introduced other co-conspirators to other of the G Enterprise agents in the case. One of those is William J.E. There was testimony at the beginning from Karen Maestrello that he was Guo's finance person and that he asked Ms. Maestrello, for example, to take a position at a company that the court has seen has a critical role in the case. That's ACA Capital. There was more testimony from Ms. Schottenheimer about Mr. J.E.'s central role in the $100 million hedge fund investment with misappropriated GTV investor funds. And then the court heard Mr. J.E. on the recordings that were introduced through Mr. Khaled and heard additional testimony. I'll just give one additional example as Mr. Collins talked about, when he was negotiating with Mr. J.E. How William told him that he and Miles had a long and trusted relationship with each other. There's Miles' son Guo, the defendant's son. There's testimony and documents that show his paper ownership of the Soraka entity and how he's the beneficiary of the $100 million hedge fund investment made with misappropriated funds. There's documentary evidence that shows his ownership of the constituent entities of the Himalaya exchange. The document that was shown early in the case recovered from the Greenwich Mansion, which Mr. J.E., trustee, holds the shares of these entities for the benefit of Miles' son Guo. Which is of course the series of evidence about the purchase of the Ferrari with investor funds. And there's the discussions on the recordings through Mr. Khaled Milson Guo is talking about the use of the Crane entity to launder funds and specifically referring to G Club investor money that came through the Crane entity as investor money. There is Mei Guo, the defendant's daughter, and her personal guarantee on the $37 million transfer from the Himalaya exchange in connection with the yacht in connection with the bankruptcy. There is Haran He, who is the paper owner of the G Club's parent entity.
The court said, "I'm sorry. Would you spell that?"
Mr. Horton said, HRAN-HE.
The court said, "Go ahead."
Mr. Horton said, he's the paper owner of the G Club's parent entity. He's a paper owner or director of numerous other G Enterprise entities that are featured in evidence. The property, one example, the entity that pays the investor money over to buy Mileson's Ferrari. And in that capacity, he communicates with other agents, and also with people outside of the conspiracy, for the purpose of obscuring the actual ownership and control of these entities and what their purposes is. There's Max Krasner, whose role is somewhat different from the sort of core group I've just described. He's more in the mode of executing tasks than planning and benefiting from the conspiracy. But he's notable for the breadth of his involvement and how he links these various parts together. There was testimony early in trial from Ms. Maestrello, who worked alongside him, that Max handled lots of payments for Miles Guo. On the first day of testimony, the court saw Mr. Krasner's role in using G Club's investor money to buy the red Lamborghini that was parked in Mr. Guo's garage in Greenwich. And there's additional documents to that effect. And on top of that, the court has evidence that he was a paper owner. Max Krasner, or director of various of the G Enterprise entities. The Rule of Law Foundation, the Hudson Diamond. Mr. Krasner signed the Soraka paperwork that's instrumental in that $100 million hedge fund investment. Beyond that, there was testimony about the Rule of Law Foundation and Society, and that involves Mr. Krasner, Ms. Maestrello. It also involved, there was testimony about Steve Bannon's statements, his actions in furtherance of this conspiracy.
The court said, "But you're not now asking that I include Maestrello and Bannon?"
Mr. Horton said, I was using Maestrello's testimony to underscore that Steve Bannon is a co-conspirator and that there were statements that he made in furtherance of the conspiracy. Early on in trial, there was a video admitted about the rule of law.
The court said, "But not Ms. Maestrello."
Mr. Horton said, not Ms. Maestrello.
The court said, "Okay. Go ahead."
Mr. Horton said, so in that context, there were statements from Mr. Bannon. I think the next category is these figurehead executives, and the court heard testimony from two of them. Ms. Reyes, the CEO of G Clubs, she makes false statements in the G Clubs arbitration. She puts together paperwork for the transfers of fraud proceeds at Mr. He's and Yvette Wong's direction. I'll just also note that she testified about a conversation she had with Scott Barnett about the red Lamborghini, the one that was purchased with investor funds. So Ms. Reyes testified about a statement Mr. Barnett made about looking for a warehouse for that car. Mr. Barnett is unquestionably at least an agent of Mr. Guo. He's described by both parties as head of security and somebody who acted for and at the direction of Mr. Guo.
The court said, "But you're focusing on Limari Reyes."
Mr. Horton said, yes, and I wanted to just note, because there are some co-conspirators and agents who make fewer and smaller appearances in the evidence. And I just wanted to point out Mr. Barnett is one of them. Jesse Brown, the CEO of the Himalaya exchange, testified that Mr. J.E. was the one who was really in control. He testified about the extent of Miles Guo's influence over the exchange's operations. Of course Mr. Khaled, who testified about his role at Crane and the entity that was created as a sort of adjunct of G Clubs for purposes of moving funds and in an effort to purchase a bank. And of course that was undertaken in conjunction with William J.E., among other of the co-conspirators mentioned. At G Clubs, moving to this category, there's Alex Hadjikaralambis, the comptroller for G Clubs, who was in charge of accounting. He reconciled member IDs with funds that were coming in before they were sent out and used to purchase goods for the Guo family. He communicated with numerous banks on behalf of G Clubs. And he touched other G Enterprise entities in his capacity as a paper employee of the G Clubs entity. There's a document that's recovered from Ms. Wang's apartment, just, for example, that shows him. Alex Hadjikaralambis, as the operator of the Freedom Media Ventures email account for that enterprise's entity's account to the Himalaya exchange. Just an illustration of the sort of breadth of the role that even some of the smaller parts played. There's Ana Izquierdo, in-house lawyer at G Clubs. On Mr. Khaled's recording, she's giving directions about funds transfers, including the laundering of fraud proceeds. She met with Beau Collins, who testified here, was instrumental in getting G Clubs a bank account at Mercantile. And Ms. Reyes testified that Ms. Izquierdo got direction from Yvette Wang and from Victor Cerda on handling the purchase of the Lamborghini that was found in Mr. Guo's garage. There are a number of lawyers who were co-conspirators and whose statements were elicited at trial. Aaron Mitchell, a longtime lawyer for Guo and the G Enterprise entities. He's a director himself of GTV. He's a director of Holy City HK Ventures. Your Honor may recall that it was Yali's involvement or her request to be involved with Holy City that was part of how Ms. Li became aware of the fraudulent nature of the enterprise. Ms. Li was asked to sign a bunch of paper for Holy City. And Mr. Mitchell was a direct. Mr. Mitchell represented G Clubs at the Crane arbitration. His law firm account holds tens of millions of dollars of fraud proceeds, including the $47 million transfer from Crane to G Clubs. And he's instrumental, as the court saw, in Mr. Guo's purchase of the Mawa mansion as a residence using investor money. There's Victor Cerda, who is a director of the Rule of Law Foundation. He helps Mr. Khaled stand up Crane as a vehicle for G Clubs related money laundering. He advises Ana Izquierdo on G Club's purchase of Mr. Guo's Lamborghini. And he worked, of course, on the Crane arbitration in which false statements were used to effect a funds transfer. There's Alex Lipman, a lawyer for Yvette Wang. After Ms. Wang's arrest, Mr. Lipman conveys a message to Yali. Please sign these documents for the Holy City Ventures, as I mentioned in connection with Mr. Mitchell. At the Himalaya exchange, the court heard statements made by Priya Patel.
The court said who?
Mr. Horton said, Priya Patel. She featured in the testimony of Mr. Roberts from BitGo and from Mr. Brown. She was held out as a representative of the Himalaya exchange to outside entities, including BitGo. She passed on lies to BitGo about the nature of Miles Guo's connection with Himalaya exchange. And Mr. Brown testified that he understood her to make false statements in internal meetings when the topic of Mr. Guo's relationship to the exchange was raised by Mr. Brown. There were also statements made in documents in which Marios Mamzaris, who was an employee of Hamilton.
The court said, if you could remind me of the spelling.
Mr. Horton said, the last name is Mamzaris.
The court said, did you say Mario?
Mr. Horton said, Marios.
The court said Marios? Okay.
Mr. Horton said, yes. So Mr. Brown testified about discussions he had where Mr. Mamzaris was conveying information about William J.E. There's also the Himalaya exchange email with BitGo that came in through Mr. Roberts, where Mr. Mamzaris, in March of 2023, is making a number of statements about sort of fundamental characteristics of the exchange and its coins that are contrary to representations Mr. Guo is making in public. And then there are people at the farms. There is extensive testimony about statements from Long Island David Xia Qidong, also in the transcript as Brother Chong Dao. Yali testified that he was the secretary.
The court said, I'm sorry. Long Island David, are you saying he has the same name as this person you just mentioned?
Mr. Horton said, that's right.
The court said, okay.
Mr. Horton said, so I think the proper name is Chidong, Qidong, and nicknames included Long Island David, Brother Long Island, and Chong Dao. Yili testified referring to him as Brother Long Island. That he was the Himalaya Alliance Secretary, the sort of umbrella organization that held and represented all the farms together. And he sent a farm loan agreement to Yili on Mr. Guo's behalf. He was the leader of the Mountains of Spices farm. There was extensive testimony about the role of that particular farm, the Mountains of Spices farm. Long Island David signs an coin-related agreement with Yili. And he tells Yili to delete the content from her phones after the defendant's arrest. There is Yongbing Zhang. Zheng.
The court said, I'm sorry. You're going to have to spell that one for me.
Mr. Horton said, so it's Yongbing Zheng. Yili testified that Mr. Zhang was a lawyer and Guo supporter who sent her a farm loan agreement that would have effected a transfer to an entity called Alpha Global. She also testified that Mr. Zhang asked her, Yili, to sue the bankruptcy trustee and, in connection with that, to sign a false affidavit, and then threatened her when she refused to do that. And then there's two sort of much more peripheral sets of statements that come in this farm's category. There's a video where somebody named Fei is speaking alongside Miles Guo.
The court said, you're saying there was an individual by that name who you're including on this list?
Mr. Horton said, that's right. We played a video where Mr. Guo and Fei are side by side speaking. And it's a video that promotes the sort of set of post-GTV investment schemes. And then there's, I'll just spell this one out. Lobnzhng. And Yili testified that this individual directed her to sign a G Clubs-related loan write-off agreement. So that's the roster. There was evidence from day one through today of statements made by the people I named in furtherance of the conspiracy and of course in their capacity as agents for Mr. Guo. And all of that, we submit, is admissible under 801(d)(2).
The court said, so are you including Mr. Barnett on the list?
Mr. Horton said, that's right.
The court said, all right. I'll hear from the defense.
Mr. Kamraju said, thank you, Your Honor. That was quite a list, but first, let me start with, maybe it's housekeeping. At page 395. Line 9 of the transcript, and I have copies for Your Honor that I can hand up, the government introduced the statements of David Dye as under the co-conspirator exception. I did not hear him on Mr. Horton's list, so we're going to move to strike that testimony.
The court said, if they had wanted him on the list.
Mr. Horton said, if I could just make two brief additions, one of which is Mr. Dye, who was the UK farm leader. He should have been included on my list. And there was a single or a small set of statements from Dara Lawal, who is Aaron Mitchell's wife. We had a sidebar on this issue. She was quite clearly communicating as an agent of Mr. Guo.
The court said, are there any other people, Mr. Kamraju, that you think they left off?
Mr. Kamraju said, yes, there are.
The court said, go ahead. Just go one by one.
Mr. Kamraju said, sure. So at 477, line 2. There is an unnamed Rule of Law Foundation paralegal who they admitted as a co-conspirator statement. Statement of agent. Do you want to ask them if they want?
The court said, yes, I do.
Mr. Horton said, so that one we had resolved at the sidebar, Your Honor, as a discrete piece of information. But for the avoidance of doubt, we include that paralegal as an agent of the G Enterprise entity on our list.
The court said, who else, Mr. Kamraju?
Mr. Kamraju said, let's see. There are unnamed Himalaya Exchange employees who, I'm sorry. I don't have the site on my chart, Your Honor, but during the testimony of Mr. Brown, there were unnamed Himalaya Exchange employees who were referred to as both I think agents and the co-conspirator exception. So I guess we can hear from Mr. Horton on those as well.
Mr. Horton said, so we think there was extensive evidence, certainly more than a preponderance, that people who were employed at the Himalaya exchange and but for Jesse Brown, those were employees of Hamilton, which was William J.E.'s entity, were agents of William J.E. and agents of Miles Guo.
The court said, so these are unnamed individuals, and so you're not asking for them to be on the list.
Mr. Horton said, to the extent they can't be identified by name, I suppose that's right. But Mr. Brown's testimony was that he met with people who were Hamilton employees, they worked for William J.E. They worked with Himalaya Exchange, and we view them as agents.
The court said, so unnamed Himalaya Exchange employees referred to by Mr. Brown.
Mr. Horton said, that suffices.
The court said, go ahead, Mr. Kamraju.
Mr. Kamraju said, so maybe we can just start. I think that's all I have on people they haven't referred to. But I'll confirm that. But I think the last description that Mr. Horton gave actually goes right to the point. The hearsay exception, first of all, for agency, is a hearsay exception for agents of the defendant, not agents of a co-defendant. So that's step one. So everything he says about agents of Mr. J.E. don't come in under an agency relationship with Mr. Guo. The only way they would be able to do that is through a co-conspirator statement. Second, if they were trying to offer that somebody is an agent of Mr. Guo's, then under United States v. Ryu, 97F.3d 648, 660, 2d CIR 1996. They need to show the existence of an agency relationship. That the statement was made during the course of the relationship. And that it relates to a matter within the scope of the agency. And the Second Circuit has emphasized that that test is very fact-specific. So there can be agency relationships when there is no employment agreement. So for example, in Ryu, the Second Circuit dealt with employees of the sheriff's department and whether they were agents of the sheriff. And the evidence that the government offered in that case was that they were, for example, hand-picked by the defendant, that they served at his pleasure, and that they received their instructions through the defendant himself, or an employee who served in a position the defendant created. The government has no evidence, for example, that Limari Reyes received any instruction from Mr. Guo. In fact, her testimony was to the exact opposite. The government also has no information, no evidence whatsoever that Mr. Guo placed Ms. Wang at a position in G clubs. There's simply nothing in the record, and I don't believe Mr. Horton will ever be able to cite anything in the record showing how Ms. Wang got the position that she did with G clubs. That's true, frankly, Your Honor. For every name that's on that list, they have no evidence to show the nature of the agency relationship. And from the beginning of this case, Your Honor, they have tried to short-circuit that showing and skip those steps. So, I apologize, Your Honor. I just lost the list for a second. But take Priya Patel, for example. They've never shown any connection between Mr. Guo and Priya Patel. Their entire argument is that she's an agent of Mr. J.E. and the Himalaya Exchange. Again, that's not what the agency hearsay exception is. So as we go down, the principal issue, I think, Your Honor, with the government's showing is, it essentially has no limitation. Their showing is somebody worked at one of these companies and took actions in furtherance of that company's business heretofore. They are a co-conspirator. They have no evidence of intent, they have no evidence of agreement. They have no evidence that they even met or spoke with Mr. Guo in any of these scenarios. So the list is long. And I know.
The court said, okay, so it's now 2:42 and you folks are going to have to do this on papers.
Mr. Kamraju said, fair enough.
The court said, it would be fine for you to go further on the record, but I think it would be more efficient for you to do it on papers. And so we're going to need to come up with a schedule.
Mr. Kamraju said, that's fine, Your Honor. I assume we'll just respond to whenever the government files theirs. So whatever the court prefers.
The court said, "This is going to have to be over the weekend. When can you get me your papers?"
Mr. Kamraju said, "And I'm sorry, Your Honor. Just for point of clarification. My understanding is that this needs to be done prior to the government resting their case."
The court said, "It does. It has to be done before then. And of course I and my assistants will also have to consult the record. And so it's quite an undertaking."
Mr. Kamraju said, "Yes. That was my assumption as well, Your Honor."
The court said, "So it looks like if I'm going to have to assimilate this along with my assistants, we will need Sunday and Monday to do that. So that means the government's papers tomorrow and defense papers on Saturday."
Mr. Kamraju said, "No problem, Your Honor."
Mr. Horton said, "No problem with us. Thank you."
The court said, "I'm assuming, Mr. Kamraju, that you don't feel the need to go further on the record. Is that correct?"
Mr. Kamraju said, "No, Your Honor. No need to belabor it now."
The court said, "Okay, so from the government I'm going to need references to the transcript."
Mr. Horton said, "Yes, Your Honor."
The court said, "Page and line."
Mr. Horton said, "Understood."
The court said, "Okay, all right. So we should bring our jurors out and let them go."
Mr. Kamraju said, "Thank you, Your Honor."
Jury present.
The court said, "Please be seated. Members of the jury, it's 2:45 and so it's time to go. Tomorrow you will not be coming in. Nor will you be coming in on Monday. So you have 4 days off. And you'll return to court on Tuesday. And on Tuesday and Wednesday we will have full days. In addition, once the parties have rested and have finished presenting evidence, and that means if the defense chooses to put on a case, they don't have to put on a case. They're not obligated to do so. But once the evidentiary portion of the trial is over, we will then have summations. Rather, we'll first have my instructions, then the summations, and then we'll go into deliberations. And at that point, once the evidentiary portion is finished, you will have to stay full days. So I want you to be prepared for that. I don't know exactly when that will be, but once it starts, there will be full days. Alrighty. So I wish you a good short break. Remember that you're not allowed to discuss the case amongst yourselves. You cannot permit anyone to discuss the case in your presence, and you're not permitted to read, listen to, or watch anything from any source that touches on the subject matter of this case. Have a good weekend.
Jury not present.
The court said, "Please be seated." So the instructions I was referring to were the pre-summation instructions, just so that you understand that there will be instructions after summations.
Mr. Finkel said, "Judge Schofield, as I understand it, does it before summations, but thank you, Your Honor."
The court said yes. Anything further?
Mr. Kamraju said, "Not from the defense, Your Honor."
Mr. Finkel said, "Just one thing. Just to avoid issues, and make sure our presentation of evidence is efficient or the defense's presentation of evidence is efficient next week. By when can we expect the defense's exhibits that they intend to introduce through their witnesses? The government has generally provided it Saturday by noon. If it narrows or gets broader, that's fine. We understand things will change. But it would be helpful to have, and I think efficient to have a good faith assertion of the exhibits they intend to introduce by Saturday before noon."
Mr. Kamraju said, "Saturday at noon is fine, Your Honor."
The court said, "Alrighty."
Mr. Finkel said, "Thank you, Your Honor. Have a nice weekend."
The court said, "Same to you."
Mr. Kamraju said, "Have a good weekend, Your Honor."
Adjourned to July 2nd, 2024, at 9 a.m.